thought it was about the dogs. Nah, it's about power. Yeah. Put up to the specialty, sunrise on the ground. Dogs in the grooming tents, whispers all around. Catalog smiles with the tension in the air. Every handshake got a hidden little snare. Bored in the back room, running quiet little schemes. Bylaws in the pocket like a stack of poker dreams. Say it's for the breed, but they guarding their throne. If you question anything, they coming for your bone. Grievance in the envelope, certified mail. Club justice system, but the day.
Welcome back, everybody. If you're new here, welcome. If you're returning, welcome back. So, this morning, we're going to do things a little bit different. I have a delivery coming in a few minutes, and so I wanted to start this kind of early. We've got about 20 minutes before we jump back into day 4 of the preliminary hearing for Tyler Robinson. And so I wanted to show this. So this is the woman who fatally shot the Army veteran in Florida. This is Andrew Branca. He's a lawyer for law of self-defense, and he's going to explain how this all works because she is claiming self-defense. And this is why she shot and fatally shot the man right here. And he's going to explain it. He's really good. And I'll link in all his information. He is really good at explaining law of self-defense. He actually gives out free books and all kinds of stuff on how to protect yourself with laws of self-defense in all states. He does a lot of training with FBI, all kinds of different stuff. He's really good at explaining all the laws, and he helps other lawyers in other states. He second chairs, does a lot of different stuff for laws of self-defense. But his name is Andrew Branca. So he gives a lot of legal analysis on a lot of cases. He did on the Anthony and Metcalf trial, a lot of different things like that. So if you want to know a lot of information about laws of self-defense, he's a really good lawyer to watch. So I kind of wanted to go through that while we wait for the hearing to start today. Sorry I wasn't here yesterday. It was a very short hearing yesterday, a lot of kind of bullshit stuff. But I will kind of get into that. But I wanted to start this first while I wait for my delivery to show up. So let's play that. Oh, I need to up my volume so you guys can hear it. And then we'll play this.
So this is what I saw. You have the armed black woman, pistol in hand. You have the white guy who's wandering along. Then he comes back, he closes on her, and she shoots him in the stomach, fatally wounds him, puts her gun on top of the car, gets on the phone, calls police. The take I saw on this says this was cold-blooded murder all over a Walmart parking spot space. She needs to spend the rest of her life in prison. And my response to that was, well, this was not a cold-blooded murder. Not based on that video clip. It wasn't. You have a man pursuing a woman around a parking lot as she's backing up, and she's got him at gunpoint. He knows he's walking into the muzzle of a gun, and she shoots him. And this is in Florida. It's a stand-your-ground state. She has no legal duty to back up or to run or to seek safety. Under Florida law, she's allowed to stand there with her gun in hand and say, stay away from me. And it really struck me that people saw just that clip and concluded it could be cold-blooded murder. She gets out of the car. She's got the gun in hand. I guess they're yelling. Now he's advancing on her. This is not a casual stroll, my friends. He wants to engage with her. Now maybe he sees she has the gun. Keep in mind, by the way, when we look at this parking lot spot here, the van just drove out of it, so now it's empty. It's 9 feet by 18 feet. right? Both those numbers are below 21 feet. And especially width-wise, that's a quick step and a lunge, 9 feet. Now she's pointing the gun at him. What should you be doing if someone is pointing a gun at you? Probably not this. He wants to say so they're 9 feet, less than 9 feet apart at this point. She's backing up. She's withdrawing, even though she has no legal duty to. And what's he doing?
Advancing.
He's following her. She's backing up again. He's following her. She's backing up more. I mean, it makes you wonder if this guy, if he's having a mental breakdown, if he wants to get shot. And now he's closing on her again. This is when the shot happens. And of course, they blur out where he fell, and then the cops show up and they cuff her, they detain her. Here's another video clip. See if it's any different. He's at gunpoint. He knows he's at gunpoint. He can see the gun, and he's closing on her, and she's backing up. If she just wanted to shoot him, she could have already shot him. And he's following her. And they're talking. And now he walks away. Eventually, I think. He's still following her. She's still backing up. Now she's closer to her car. She's backing up to, it's like the bumper of her car. He looks like he's going to finally give up and walk away. He lives. She takes a couple steps forward. It looks to me, by the way, people say she pursued him. I don't see pursuit here. I see he walked past the car. She took a couple steps forward so she could peer over her A-pillar and keep eyes on this guy. She doesn't go past that side mirror. She leans herself against the car. Clearly, she's not going any further. And it's not imprudent to keep eyes on people. A lot of times people will walk away from a confrontation like this just to go to their vehicle and get a gun and come back. I would keep eyes on them too. But you'll see, she backs up by the corner here. He walks across. It looks like he's going to walk away and live. She steps up behind her side mirror there, leans on the car. She's not going anywhere. And then he comes back. He comes back again. And that's, of course, where he gets shot. So just based on that, let's take a look at the Florida self-defense statutes. So 776-012, use or threatened use of force in defense of persons. A person's justified in using or threatening force. Paragraph 1 is non-deadly force. So you can use or threaten force except deadly force. And it's all the 5 elements of self-defense here, except you don't have a duty to retreat, right? So we'll see it when and to the extent the person reasonably believes, so there's reasonableness, the conduct is necessary to protect himself against the other's imminent element of imminence, use of unlawful force. Innocence is dealt with differently. The force is immediately necessary. Do they use that word here? Is necessary. And of course, it's non-deadly force here. So that deals with the proportionality issue. And then paragraph 2, we get to the deadly force. And it just incorporates everything having to do with when you're privileged to use non-deadly force in self-defense. And then it adds additional conditions, right? You can't use deadly force unless the threat you're defending yourself against is one likely to cause imminent death or great bodily harm. A deadly force threat to get deadly defensive force justified, or the imminent commission of a forcible felony. There is no duty to retreat. You can stand your ground as long as you're not engaged in a criminal activity and you're in a place where you have a right to be. She's in a Walmart parking lot. Now, you might say, well, she was engaged in criminal activity. She got out of a car with a gun in hand. That should be brandishing, which would be a crime. It could be aggravated assault with a deadly weapon, which is a very serious felony. The trouble is, even if that's true, that conduct can constructively have ended, especially when he's now pursuing her and she's backing up. Indeed, even if she had provoked a confrontation, so the element of innocence is really dealt with by a different statute. 776-041, use or threatened use of force by an aggressor. So if she was the initial aggressor because she came out with a gun, let's say she was the initial deadly force aggressor in this confrontation by getting out of the car with her gun in hand. She would normally lose self-defense, but she can regain self-defense under 2 circumstances, right? One is if the other person if your only act of aggression was non-deadly and the other party escalates to deadly force, right? That's something they do under circumstances of escalation. Their escalation to deadly force was unjustified. You can defend yourself against their unlawful escalation to deadly force following your merely non-deadly force aggression. But the other way is if in good faith the person withdraws from physical contact, indicates that they want to terminate the confrontation. Once she starts backing up and he's pursuing her, I would argue she qualifies for having regained innocence, even if she lost it by getting out of the car with the gun. Now, of course, there's a lot we don't know. We don't know what they're saying. We don't know what kind of, provocation with intent issues there might be. But at the end of the day, we have this video of her backing up somewhat relentlessly and him continuing to pursue her. By the way, another issue that came out of is, I just want to point this out because people get this confused quite a bit. This account wrote, getting out of a secure car with a gun in hand without them even advancing towards you. And I would just point out, a lot of the video we're seeing is in this vertical orientation. And what's not in a vertical orientation, a lot of times people are off screen. So we don't know how far people are or what direction they're moving in. But it's getting out of a secure car with a gun in your hand without them even advancing towards you to try and egg on the situation. We don't know that's what's happening. Isn't the best idea either, especially claiming you were in fear. And people mention this a lot. The fear is not actually an element of the legal justification of self-defense. We will phrase it that way when we're speaking colloquially, right? You can't use deadly defensive force unless you're in fear of deadly force harm. But speaking more properly, fear is not an element of self-defense. You need to be in apprehension of harm, but fear is an emotion. It's not required that you actually be frightened. That's not an element. You have to have apprehension of imminent physical harm, but that's different than fear. In fact, if you look...
Okay. I brought my stuff in. It was delivered. Sorry about that. Okay. Let's get back to this.
Look at Florida's self-defense statute. In fact, I can't recall ever in any state self-defense statute actually seeing the word fear. Sure. It might be in some of them, I guess, but it's not in Florida's. I mean, here's the statute right here. I'll do a search. Fear. 0 out of 0.
Be right back.
There's no fear in the statute. And then people get very upset with me when I say that. They say, oh, Andrew, it's just semantics. Okay, well, semantics matter in the law. Another account here writes, the initial bad act was her getting out of the car with the gun, he writes. And that's nonsense. I mean, it could be true, but it's not definitely true. We don't know why she came out of the car with a gun in hand. Maybe she has an explanation that would be legally justified. So it's not automatically the case that people, a lot of these people, it's just a black woman shot a white guy and they want her because of the race dynamic to be in the wrong, be a bad person, have acted unlawfully. And their analysis is not analysis. It's purely driven by emotion. And it's very low IQ. For example, if you just talk about this initial clip, right, which just shows the confrontation right around the car, the moments before he shot. He's walking sideways. She goes up to her mirror. He comes back, approaches her, closes on her, gets shot. People seem to be unable to have the capacity to just limit themselves to these specific facts and do an analysis like it's a hypothetical limited to those facts.
Right.
They want to automatically say, well, she got out of the car with her gun. Well, maybe that's a different analysis, though.
Right.
And to me, it's very reminiscent of law school, like exam questions. This is a common structure. They'll throw 5 facts at you and ask you to do a legal analysis.
Right.
And then they'll say, well, how does that change if we add facts 6 and 7? And you do it again and you explain the difference.
Right.
And what if we add 7 and 8? And you do it again and we do the difference. But if I went back to the first question with just the 5 facts, even having been informed of the others, I'd be able to do an analysis based applying only the 5 facts.
Right.
Just pretending I don't know the others. And people seem unable to do that. What I see when I look at this clip here, this is the one I'm talking about. He walks across the lot, then comes back and closes on her.
Right. He just needed to walk away. If you're only watching this clip, and this is where people have to wait. And wait for all the facts to come out. Everybody wants to be a sideshare lawyer, right? Or just look at a 30-second clip. We're all looking at 30-second clips, not even a minute long clip. We're looking at this. Why didn't he, if she's even just standing there with a gun, what do you do when somebody's just standing there with a gun? Just walk away. Why is he advancing? If we're just looking at this clip, why are we even guessing that she got out of the car, that she waited for him to come back out of Walmart, whatever? We don't know those facts yet. If we're just looking at this clip that was released, he advanced on her. And so therefore, it is, her right to protect herself. It would be your right to protect yourself. So we can't look at everything else. So you have to wait for all the facts to come out.
Into her presented pistol.
Right.
And gets shot dead. That looks to me a lot like self-defense. It certainly doesn't look to me like it can only be anything. It can only be cold-blooded murder.
Right.
I just don't see that at all. Anthony Cumia seems to, and I like Anthony Cumia a lot. He was a talk radio host, a comedy talk radio host. It was Opie and Anthony was the name of the show, and I really enjoyed that show when it was on the air. And I think Anthony Cumia is a pretty smart guy, but he's got this race derangement syndrome that seems to strip away his ability to reason. This account here had written, whatever disagreement these two had in the full video, she gave that man many chances to walk away while she pointed the gun at him. She appeared to responsibly use the firearm as intended. She first brandished the firearm, making it known she was armed and ready to fire if necessary. After multiple requests for the man to walk away, he made the unwise decision to start walking towards her. Based only on viewing the video and applying due process scrutiny to what we witness in this video, just the video, I currently conclude this shooting was justified. And Anthony Cumia responds, you know nothing about the laws governing firearms in Florida. You can't brandish a gun without an actual reasonable threat of great bodily harm against you. She should never have drawn the gun. Maybe she shouldn't have initially drawn the gun. But now the gun is drawn. She's backing away from him. He's walking into the muzzle of her pistol. And maybe she had a reason to brandish the gun.
Right.
I responded to Anthony here. I said, he wrote, you can't brandish a gun without an actual reasonable threat of great bodily harm. That's not really true. That's not really true. You can't shoot the gun until you have a reasonable apprehension of imminent deadly force harm. But there's many circumstances in which you can present a gun as a defensive display to deter having to actually use deadly force. I don't know where Anthony lives. He might live in a state like New York or something that makes it, a defensive display very difficult. But it's not difficult in Florida. The vast majority of self-defense uses of firearms, there's no shot fired. It's
not difficult in Ohio. You're allowed to open carry in Ohio.
Precisely a defensive display. Now, every time you make a defensive display, are you running the risk that you could be charged with a crime like aggravated battery, like brandishing? Yes, you are. But the defensive display can be legally justified. It's possible. It's possible. We all have a moral and ethical duty to defend ourselves and our family from criminal violence. But sadly, many people make themselves vulnerable to prosecution because they only think they understand the law of self-defense. Learn the actual law of self-defense and make yourself hard to convict with our free, plain English, best-selling book, The Law of Self-Defense Principles. Grab your free copy right now at lawofselfdefense.com/free book.
You should definitely check that out. I definitely recommend it. I have one. I think everybody should have one. You should definitely check Andrew Branca out. He's on YouTube, on X, on Rumble. You should definitely go check him out. He is definitely an awesome lawyer. He explains everything in layman terms, too perfect. I watch him all the time. When I was watching a Law Tube Sphere all the time, he was definitely someone I would follow. And I definitely recommend everyone go follow him. So. But I wanted to show that. So I definitely wanted to play that because I just want to show little clips and things like that of different different lawyers that I follow, different lawyers that I watch, and kind of get you guys looking at different lawyers and stuff that give a lot of good analysis on law cases and things like that. They give really good analysis and things like that are actual lawyers. Instead of just that actually have law degrees and stuff like that, instead of just side chair commentary. So in case you want to check them out, definitely think they're worth giving a look to. So this should start here soon. This is day 4. Yesterday was a lot of arguing over what we're allowed to see and what we're not allowed to see. What will be admitted and what won't. Give me 1 minute. I'll be right back. Okay, I'm back. Sorry, I had to get the dog situated, get the glass, do all that. Hopefully. Hopefully this starts soon. Hope you guys are enjoying some of the content. If there's something that you guys want to, I can put this up, get rid of that. Okay. There's something that you want to deep dive into or something you want to talk about or want me to break down or look into, drop it in the comments and I'll do that. Definitely want to sorry. Definitely want to show what you guys are interested in, or trying to do a little bit of more stuff and kind of look around for other things. Also going to show more of this guy. You guys share this while we're waiting. This guy here, oh my God, he is so funny. I'm going to show some of his stuff too, do reactions to his. This guy is awesome. And I love his takes on stuff. He really explains a lot of stuff. Love this guy. So I'm going to do a couple of his videos, do some reactions to his videos. Really good guy. Really super nice guy too. Super nice. But I watch a lot of his videos. But he does a really good breakdown of what police should be doing, what they shouldn't look like. He critiques the officers and everything as well. While he's going through it, he stops it, critiques the officers, maybe what they should have done better, things like that. So he gives a really good breakdown of a lot of things. So I really like him. So I'm going to do some of his. I'm going to do some funny videos too. Just like cute pet videos, cute things that just kind of pull a bunch of stuff into. And I would do some murder mystery videos. I watch those a lot. It looks like they're moving the camera a little bit. Just want to kind of make it so that we're not stagnant on everything. And I don't want it to be all doom and gloom all the time. The world's too much all doom and gloom. So I want to add some funny stuff and cute pet videos, funny videos of just a bunch of stuff. There's a guy who does funny videos where the dogs are talking and stuff like that. Oh, my mother-in-law loves those. She sends them to me all the time. I think his name's Rockstar or something. So funny. I think those are cute. So different things. I don't know. I just thought I'd switch it up a little bit instead of just how sad the world has become lately on just everything. And I know that people have like a bunch of different interests. So if there's anything that you want, there's a boat guy. It's called the Dan Show. It's called the Big Dan Show. I watch him a lot. You want to watch something that's really relaxing, look up the Big Dan Show. He does this guy, the Big Dan Show. Oh my God. And you want to talk about watching something relaxing at night? Oh, incredible. Not only is he funny, but he was in the Coast Guard and stuff. So he watches like boat launch fails and stuff like that. But he's also very educational. He shows you like what you should be doing. He like talks to people, says, oh, you should have done this or that. But he's like also funny, but he's also like very educational about boats. I've learned so much about boats, and I don't own a boat, but I've learned so much about boats by just watching this guy. And so I got my husband into it. And so we like watch it at night while we're laying in bed. It's so funny because he's like, "You got Dan on?" And I'm like, "Yep." And so we'll like watch Dan show, the Big Dan show, like laying up in bed, just watching TV. Me and the dogs and him, and we're just like watching such a good show. And he's so informative. But it's also funny because he like also like laughs and jokes and has a good time, but he also, informs you about boats if you want to know about boats, but it's also very relaxing. It's like stupidly relaxing. So definitely check out the Big Dan show, subscribe to it. Relaxing and funny because it's crazy how many people like have boats that don't know how to drive a boat, it seems. But hilarious. So check that out. I don't know. It's just things that I watch, things that interested in, stuff like that. Just trying to put a bunch of information out there that, like, hey, check this out, check that out. Because nothing, like, life is too short to be so serious all the time, right? You gotta have some fun, some relaxation, some, I don't know, funny moments. Oh, and that Dan guy, he like gives away stuff like on his channel too. Like if you're watching it throughout the channel and stuff, they do like drawings and stuff like that. I don't know if you own boats or whatever that would help you, but like super nice guy. No, no. But yeah, there's like, I don't know, just all kinds of stuff. So if there's anything that you guys are interested in, let me know and I'll deep dive into it, break it down, we'll watch it, make clips of it, do reactions to it, whatever. So like nothing's off the table, like, uh, just like be like, hey, check this out or whatever. And we'll do some reaction videos to it. And oh my God, when are they going to start? It's already 11:12. So I'm like down for anything within reason, like no like weird stuff. I have to watch YouTube. But yeah, I think it's like there's like a lot of cool stuff out there to watch nowadays. There's people that watch like movies with people. Like there's like movie watching people, like you can watch movies together and like be like, I don't know, like talk about the movie and all kinds of stuff. I don't know, there's all kinds of stuff. But I don't know. I'm just trying to find what interests people the most that doesn't have to do with all doom and gloom all the time. Oh my gosh, they're running late. They keep moving the camera, but doesn't look like it's going to the judge. Maybe I should find something else to watch until. Oh. Hmm. They mauled a wolf?
Popped up on my
What?
All right, guys. Yesterday, this popped up on my Facebook feed. It's from the Facebook group. Now, that's what I call bad breeding. A large number of their posts are about the exotic bully dogs, which are absolutely terrible, which I've done a couple of videos about. But this one was a little bit different. and it's about wolf dogs. Now, the post,
Don't worry, I'm watching the other feed just in case.
is particularly targeting one kennel called Northern Wolven Shepherds, which I've nothing to say about. I don't know anything about them at all. But it made me think about the ethics of wolf dog hybrids. This post commented on merling. There's more breeds of dog that are being merled than ever before. They've merled Cocker Spaniels, they've merled Poodles. So they've done it to wolf dogs. And these are striking dogs. These are beautiful dogs. I mean, I could understand why people would want one of these dogs. This is a long-coated Merle wolf dog with blue eyes. He embarked at 41.9% grey wolf. His dog breeds are Australian Shepherds, that's where the Merle comes from, German Shepherd, Alaskan Malamute, and Siberian Husky. And then this one, Merle wolf dog, he is super social, not knowing a stranger, loves to jump, and is super food motivated. He embarked at 45.2% grey wolf. He's half Australian Shepherd, with the rest being Alaskan Malamute. Now, again, I've not got anything against this kennel, the Northern Wolven Shepherd kennel. Don't know anything about them at all. These are striking dogs. We're talking generally about wolf dogs. Last year, here in the UK, this hit the national press, and it was in Preston. 3 what were originally deemed German Shepherd type dogs
German
were
Shepherd.
found roaming Preston, which is a city. It's the nearest city to me. It's about 15 miles away from where I live. Do they look like German Shepherds to you? Come on.
Yeah.
A member of the public rang, I don't know who they rang. They rang the council, they rang the RSPCA. I don't know who they rang the police. That there were 3 wolves roaming the city. And they were caught, and they were originally deemed, laughably, as German Shepherd type dogs.
No.
It quickly became evident that they weren't pure wolves, but they certainly weren't German Shepherds. They were very skittish. They were completely unsocialized. Somebody, I think, has had a litter of wolf dogs, couldn't sell them, and has dumped them. I think that's the thing that's most likely happened. They were only young dogs, but they weren't tiny puppies either. And millions of people followed what happened to these 3 poor dogs. A charity called Wolves of Wiltshire got involved, and they got DNA tested. They embarked the 3, and they came back as 49.1% grey wolf and 50.9% Czechoslovakian wolf dog. So they're very wolfy. To be hanging around on the streets of Preston, these were very wolfy. Actually, higher in wolf content than I thought they'd be. Anyway, they've got a home. I don't know whether they'll be ever able to leave the wolf sanctuary, but that's where they are. It caused a little bit of a stir, honestly, in the national press, let alone my local press. But an RSPCA spokesperson said they are large, much more challenging animals. This is wolf dogs that need experienced handlers who have not only worked with dogs, but also wolves and understand their needs. They also went on to say they don't make suitable family pets for most people. Like, they are striking. I can understand why people would want a wolf dog, but there's a lot of problems with them. Yeah. People think, well, if I get a low content wolf dog, then it'll look like a wolf and behave like a dog. Just lie on the sofa and be a complete couch potato. I'll have a wolf in my living room. It doesn't work like that. Low content wolf dog technically is anything with less than 50% wolf. And by that then, these...
Okay, are we moving, or are we just shaking the camera? Just shaking the camera.
3 beautiful creatures would be considered low-ish content wolf dogs. Lowish. I would say the more moderate, because the Czechoslovakian wolf dog is also part wolf. So the 49% grey wolf and then nearly 51% Czechoslovakian wolf dog. This is Wisdom Panel. While an experienced owner might make this dog work well in their home, They tend to be suspicious of strangers, they have a strong prey drive, and they may get into trouble because of that. But they were developed as a biological experiment in 1955. After 10 years of experiments, breeders determined which of the wolf and dog qualities to select for. And, according to Wisdom Panel, no additional wolves have been introduced since 1983. Today, Czechoslovakian wolf dogs are known to be a powerful breed with exceptional senses and incredible stamina. Some dogs have even completed endurance tests, and they ran 100 kilometers, which is about 60 miles, in 8 hours. And the Czech Republic and Slovakia selected the Czechoslovakian wolf dog as their national breed. Well, you can understand why people will want them. And again, an experienced owner who has the space and the time to dedicate to one of these beautiful dogs, yeah, have at it. But for the average person, think about this. You might think, well, I want a dog that looks like a wolf, who'll be a couch potato, who'll behave like a dog and look like I've got a wolf in my living room. Even an extremely low content wolf dog, for example, less than 20% wolf, if they've got wolf on both sides of their ancestry, which you're not going to know necessarily unless you do a DNA test and actually look at the content of wolf and dog on each chromosome, you wouldn't know this. And the reason why I'm making this point is because we know that wolves and dogs are genetically so closely related that they can still breed to produce viable offspring. Different species can interbreed, like donkeys and horses, but they don't produce fertile offspring. Lions and tigers can interbreed, but they don't produce fertile offspring. They're too distantly related from each other. But wolves and dogs are so genetically close that they can produce fertile offspring. This is why these multi-generational wolf dogs, like the Czechoslovakian wolf dog, that's why they exist. Their offspring are just as fertile as any other dog or any other wolf. There are a few genes, possibly into the hundreds, but some specifically that we know about, that determine why wolves are aloof, fearful of strangers, very nervous, tend to be skittish, and even the most highly socialized wolves that have been brought up with humans don't get to the level of, I guess you would say, domestication that dogs do. Dogs with less socialization than the more socialized wolves are still more friendly than the highly socialized wolf. Why? Because of a handful of genes. And I talked about those genes in a video that I did a while ago on the origins of the domestic dog. But one of them is incredibly interesting. This gene difference in the domestic dog compared to the wolf was found in 2017 by researchers at Princeton University. Quoting here, in 2017, my team discovered that dogs and humans with Williams syndrome share a handful of genetic variants. Both are connected to friendliness. This sharing goes even further, where the same genes carry these variants across the two species, indicating a shared common genetic mechanism. Williams syndrome is diagnosed in humans when people are missing a large chunk of DNA composed of around 27 genes, which produces a suite of mental and physical traits, which includes a bubbly, extroverted personality. Like people with Williams syndrome just do not know a stranger. Of these 27 genes, a handful appear to be critical for the syndrome to manifest. While dogs are more human sociable than the average wolf, there is still variation between individual canines. While Williams syndrome is due to a large deletion that removes these genes, canines have novel insertions of tiny bits of DNA that work to disrupt those donor genes. Thus, both species, different genetic reason, but the end result is the same. It results in disrupted genetic function of the same genes. All right. Now, it doesn't mean to say all domestic dogs have Williams syndrome. We're not saying that. But that excessive friendliness compared to the wolf is in large part because of this genetic difference, which probably occurred millennia ago and enabled wolves who were hanging around human camps to be friendly enough, to be trusting enough to live with humans in the first place. Dogs domesticated themselves. Now,
Looks like we might be getting started.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Ms. Erica Kirk. Sorry. Good morning, Ms. Kirk. All right, as you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense. All right. As we begin this morning, I wish to, I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we've came back on record.
Ooh.
One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed
Let it all play.
by the attorney for
Now,
victim representative Erica Kirk to the state.
Woo-hoo.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and
Right.
indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard.
Not only that, but
To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading.
you're not going to like it.
I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution.
He's giving you
I
a
think that
lot.
the rulings that the court has made the last few days do so.
He's
And
pursuing
I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Ugh. You just don't want
Only
the.
briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this 3-step process. And I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are 3 separate inquiries. Of course, the media believes, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. Maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we of course support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing
For,
the briefing that was submitted last night.
all right, so I want to address the motion filed by
Erica
the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed.
He's actually.
So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides.
He's just leaning.
Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Ms. Robinson's constitutional rights. Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit.
More? I do, and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record, and then I'll hear from you. I just want to make sure you're able to be afforded everything. Minutes. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties? Yes. All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
I mean, he is doing a good job. People don't like it because they want to see everything, but they want it played because it's his admission. He admits that he shot Charlie Kirk.
Your Honor, and then
recording.
Let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is where I'm going to next. Mr. Ballard.
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here in this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twigs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page based on what the court just said.
So no text messages.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second, we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short. And so I'll leave it to the state if you wish to just in real time pause and fast forward, or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
These got to be the screenshots, which were already subpoenaed.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach.
Just don't play it. Just don't play it. How about that? Oh, wow.
When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and of would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence. And I would like to be able to point the court to those. We've got two brief portions that we believe don't implicate those concerns and should not be redacted. Does Your Honor have the transcript?
I do.
In front of you? Okay.
He's really leaning towards the side of caution for appeal. Really leaning. Really leaning.
First of all, at the very, very bottom of page 10, beginning with the words, "was he?" And then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19.
It's going to be another day of
And it begins,
redaction
let's see.
argument.
It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
They should just bring Twiggy in. Put him on the stand. Then they don't have to do all this.
Yes, you may.
Thank you, Your Honor.
Oh my God.
With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twigs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon. But from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript, which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twigs' representative, but I think as a witness
Well, then bring him in.
who has counsel,
Then bring him in. Subpoena him in and put him
there
on.
might be something that Mr. Twigs' counsel would want to say about this as well.
So then
I don't know what it
bring
would
him
be,
in.
but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Thank you, Your Honors. Mr. Novak recognized Mr. Twigs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twigs and identifying information about him. And then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with was he, and ending at 1646 with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that may be played and published through all mediums.
We're going
in
to be
courtroom and
so
via video.
on this damn.
Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307.
Correct. Yeah. Yes. In right after 3255, where
All right.
Mr. McBride states,
This is
okay.
why cases take so
I
long.
see. Thank you.
So everybody
Let me
knows.
just take a quick second to review this.
That's why it takes years.
In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with OK, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast.
Use a grand jury.
I note and I recognize Mr. Novak's statement as it relates to what Mr. Twigs' counsel may or may not assert, but the court finds independently that this
They don't use a grand jury here, though. They use preliminary.
this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340 may be published.
What?
Did that notation make sense?
No.
Did to the state, Your Honor.
All right.
Oh,
to the defense.
okay.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note the defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Like a dead horse. You beat it to death.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case. And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately released that recording to the press, who then publicized and televised that, the defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate.
I thought they were talking. Tyler did that. I was like, what?
Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value. And even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And the court, because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case, This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No,
Thank you.
not this time.
Well, here we go.
Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that
He ain't lying.
blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve.
Right, carefully.
But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Well, if you don't like cameras in the courtroom,
Thank you.
you don't like us to see what
Mr.
you're
Ballard.
doing. I think there should.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom, not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public.
Yep.
And the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
Unfortunately, that's your First Amendment right. To know what the judge is relying on to make a decision.
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like a transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleve below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stressed what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that middle step is a meaningful one. And if the court were to decide that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Good argument.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and and they have a right to hear the evidence.
Oh my God.
They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you are viewing. They want to see the evidence.
And what you made your conclusion on.
And we understand you have to balance, but at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to
Please.
make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
It's for appeal purposes.
And just to be clear, as it relates to the state's request, 16.6, so under the three factors or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
All of it.
We are asking,
For all of it.
we,
And this is why all those lawyers are sitting there.
Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. Just the court just wants to.
All day yesterday? Well, no.
And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
And this is why you don't publicly assassinate someone.
And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public
All of it.
prior to these proceedings?
I mean, a huge.
And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing and it's a factor. So I want to make sure that issue has been presented by the parties
Everybody?
if you choose to.
Kind of like the Lori Daybell case. It was Dropbox to some.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears in that in the information? Again, I'm just trying to create a record of what is out there from your perspective so the court can consider that in its analysis.
We'll ask who filed a FOIA report on all of it. Go on Reddit and find out. Go on Discord and find out who filed a FOIA and then disseminated it to the world. Welcome back. We're still on arguments from yesterday's Discord chats, text messages, and the movie, the interrogation. We're still arguing about whether or not it should be shown. Well, he didn't miss anything. He's still deciding whether or not he's going to let it all out because it's public knowledge anyway. So now they're trying to figure out how much of it is public knowledge and who all filed a FOIA for all the information. I mean, he's not figuring out who filed a FOIA. I said that he should just ask and file the FOIA and got the information disseminated on Reddit. I do like the lawyer that talked yesterday. She must have been an English lit student. She properly used whom. I love that. I'll be right back while they're talking.
Your Honor, State's Exhibit 16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication. It's in the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on state's request to publish exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rizzo and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rizzo because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing.
God, really?
The defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rizzo, Estes, and Skilling. Unlike the broadcast interrogation in Rizzo, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional.
To see what they were.
The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial.
What do you use them for?
This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on exhibit 16.1, because it contains information, including a phone number and address, to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court.
Oh.
Counsel, how would we like to proceed?
He looks so disheartened.
Your Honor, just to clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right, I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at at 10:50. Court is in a brief recess.
He looks so upset. Wow. Okay, I'm gonna finish watching this. There's not much left to it.
The friendliness of domestic dogs. We know that there's oxytocin differences, for example, in dogs and wolves.
Yeah.
But the point I'm making is that if you have an extremely low content wolf dog that has wolf on both sides of its ancestry, how do you know that those genes from the wolf haven't come through to your wolf dog?
100%.
And you don't have the genes that make your wolf dog friendly. And you end up with this really aloof, really nervous, very wolfy, low content wolf dog. I think we need to know a lot more about the genetic makeup of wolf dogs, not just the percentage of wolfiness, but about the actual genetic mechanisms that are making up the temperament.
Is that who this is? I can go there and tell people to be free. Own what you want. No one likes me. No, somebody made a Merle wolf.
Of those wolf dogs. And I think wolf dog breeders,
That's what this
by all means, breed Merle wolf dogs if you want to. By all means, produce long-haired, strikingly beautiful wolf dogs. I have no problem with that, honestly. But I think it's the temperament that needs to be focused on above and beyond their looks, because there needs to be some kind of mechanism in place to ensure that the wolf dogs that are being bred and sold to people, they have the friendliness genes and they don't have the wolfy genes that mean that they are really difficult to get on with. So while I agree with this group about their opinions,
Look how it still looks like a wolf. Still has a face of a wolf. I mean, you can't deny that's a wolf by looking at it.
on the exotic bullies, which are just so incredibly unhealthy.
Yeah.
I do have to say, look, if people are breeding Merle wolf dogs, have at it. But I'd like to see more done on understanding the genetic makeup of wolf dog lines. That's my take. Let me know your thoughts in the comments. I'll see you in the next video.
Yeah, I mean, I can't believe how much it still looks like a wolf. Can't get rid of that trait. Yeah, well, I mean, but like I think you just look at the eyes and see it. Me personally. Oh, Springer's with Cassie. Yeah, I guess. Yep. Oh, I say all the time dogs derive from wolves. People don't believe me though. They like to argue. So those eyes aren't the hard eyes, but also it is. Look. Okay. Oh my God. Husband laughs after wife found dead inside his car. Oh my gosh. That's crazy. This is such a crazy story.
When authorities in Vinton County, Ohio, reportedly discovered 16 children ranging in age from 1.5 to 18 years old, locked away in a feces-covered 12 by 12 room, barely able to communicate with serious medical conditions, the question of who to hold responsible became an immediate one. And the answer was pretty clear. As we reported yesterday, 4 adults also lived in that house. The children's parents, according to one of their lawyers anyway, 33-year-old Elizabeth Siders and her husband, 36-year-old Gary Siders Jr., his parents, 67-year-old Christina Siders, 73-year-old Gary Siders Sr., all whom are now facing multiple charges related to these horrific conditions those poor children were allegedly found in. But the more we learn about the family's past, the more shocking this entire case becomes. LA Magazine contributor Lauren Conlon has been digging deep into this Ohio house of horrors. Her latest article just dropped this morning. She joins me live now. Thanks so much for taking the time, Lauren. What have you learned about the kids' parents? Because we reported yesterday that Elizabeth, the mother, was only 15 when she got married. What did we learn about
And that's not legal. Not in Ohio.
their education, their work? What more can you tell us?
Yes, well, I've been digging a little bit further, as you said, and something I came across today was the fact that Elizabeth and Gary Siders, she gave birth in 2022 to conjoined twins at 24 weeks,
Oh my
and
God.
they subsequently passed away. And Jesse, she gave birth to these twins in a local hospital. And I found that very noteworthy here because a lot of people are wondering, did she give birth to these 16 children in this house, this rental house?
16 children.
You know, there's a lot of questions. There's a lot of things that are unknown. I mean, there's a lot of things right now that Elizabeth Siders' attorney doesn't even know. And he's kind of said this.
That is so creepy looking. It's like the hills have eyes.
He's kind of said, look, I asked the public to reserve the judgment, so to speak, because we are still trying to figure out if she might be a victim here. Because Elizabeth Siders was able somehow to marry Gary Siders, as you said, when she was 15 and he was 18 years old. They had to go to West Virginia where they got a precise.
That's how. Because I was to say it's not illegal. It's not legal in Ohio. It's like every few years some story comes out. And it's odd and hot as shit, yeah.
Judge to sign off on this because she was a minor, as well as her parents, and that marriage.
Well, her parents had to sign. Because see, I got married at 16, but I got married in Vegas at 16, right? And I had to have one parent's signature, which my dad signed.
Certificate and all of that information stated that she had completed only the 8th grade by the time she was 15, and Gary Siders had completed the 9th grade. So, I mean, there's, again, a lot of layers here. And also, I want to just let you know, the four of them actually waived their preliminary hearing today. So this case is going to go directly to a grand jury, and they've actually appointed a special prosecutor as well.
Yeah. And so in Las Vegas, you can get married at 16, but you still have to have one parent's signature. I lived in Vegas at the time, though. I mean, we moved to Vegas, lived there for 4 months. And then I was like, yeah, it's enough of this shit. And then we got married and moved back.
That's interesting because usually a defense attorney would say, hey, I want to see what the prosecution has. It gives us an opportunity to prepare. By the way, you talked about knowledge, okay? And I thought this was interesting. From all accounts, beyond the grandparents, the Siders were very isolated. There were other family members who didn't even were.
Could you imagine living that close to the railroad tracks?
aware of the number of children that were in the family, right?
Yes, and that was shocking. So I was doing some digging on Facebook, and I did find a couple of Facebook posts from her brother. This hasn't been verified by law enforcement, but I am certain it's her brother. And he kind of made a comment. You know, he hadn't seen his sister in 15 years. He just recently saw her for the first time. And he made a comment that he thought she was almost indoctrinated. There was another comment made about welfare. He kind of surmised that, quote, the state knew. Again, we still don't know what the state knew, if anything, but reportedly, there were no signs that the children were born inside of that house. Now, there are also reports that this family did move around from county to county to sort of evade all of this type of attention, but this is not a big house. We're talking about 16 children in a 12 by 12.
16 children is wild to me. A person having 16 children. Of course, that's like, what did those one people have? Like 19 kids and counting, or some weird shit.
12 area. I mean, it all sounds so horrific, Jesse.
Who were apparently, or some of them, in this alleged condition for years, not going to school. By the way, just going back to the amount of kids.
Wait, not going to school?
There were, for years, there were some media reports that put the total number of children that were birthed by Elizabeth at 20, and she was as young as 13 when she, apparently gave birth. What are those reports based on?
Yeah, I mean, that's interesting. I clearly, we've found one miscarriage, unfortunately, that surfaced, and we don't.
I never had any kids. Never had any miscarriages, never had an abortion, never had children. I didn't want any kids.
Don't know yet the exact total, but I have also seen this floating around on Facebook. I have not been able to verify that just yet, but I kind of believe it. I'm really not putting it past this, these people at this point. And I'm so disturbed in so many ways because, her lawyer came out and said,
oh, I'm glad she got rid of that echo.
Elizabeth Siders, she was exhausted. She was crying. Most people ask, when can I get out of jail? And she's asking about these children. But how do you have these children in this type of conditions?
Well,
I mean,
I think he's trying to lay the seeds for some sort of mental health defense. That's my guess. Before I let you go, by the way, the way everybody found out about this was there was a warrant against Gary Siders Jr. for public indecency. Do we know what that was about?
What?
Yes. So there was actually 4 different occasions in May, like days apart, Jesse, of this indecent exposure charge. They were serving a warrant that day, which was June 30th. And obviously, that didn't exactly happen. But the criminal complaints in Ohio or in Vinton County, I pulled it. They don't give a lot of information except there was 4 separate occurrences in May. And he actually is supposed to be in court tomorrow, but that may be pushed back. So the docket says 10:45 a.m. on Thursday, but I've heard it might be moved because of this case.
I'm sure we'll learn more information about that. Lauren Conlon, great reporting as always. Appreciate it.
Thank you for watching. Subscribe.
Why is Chris Como on there? Oh, it is News Nation. No. Yeah, right?
And they looked like almost feral animals. It was terrible.
16 children, a filthy house, and a secret investigation. We're learning more about the Siders family in Ohio, the children who were found in the home, and what family members of the mother of the children are saying after the arrest. Plus, the attorney for one.
Is that what she looked like prior? Holy crap.
Of the family members is here.
We don't have all of the evidence. We don't have anything that's showing that these kids were locked in a basement or anything of that nature. This is not what people are trying to portray.
Can't play that.
Crime Fix, I'm Anjanette Levy. It's been nearly a week since sheriff's deputies and state agents went into a home in rural Ohio to execute a search warrant and found 16 children in a room that was described as filthy. Those 16 children are the daughters and sons of Gary Lee Siders Jr. and Elizabeth Siders. They are
16 children is wild. Yeah, loose running around, feral children.
Are facing 16 counts of child endangering, and Gary Jr.'s parents, Gary Siders Sr. and Christina Siders, are facing.
This guy here looks creepy as shit. Just saying.
The same charges. The state's attorney general, the Vinton County prosecutor, and the sheriff described the conditions in the home as filthy, with feces and bugs in the 12 by 12 room where they say these children were kept.
Some of these children couldn't even speak. Yeah, so
wait, couldn't speak?
I mean, we're talking. This is very. It was terrible. I mean, they looked like almost feral animals. It was terrible. So when we're talking reading and writing and education, we're talking a whole nother level of expectations here.
The children range in age from 1.5 to 18. 2 were taken to level 1 trauma centers. The others were treated and released from a number of hospitals and then placed in foster homes. The home on Omer Street is roped off by crime.
But how can they not speak? They have 4 people living with them. They didn't teach them how to speak at all?
Tape to keep people out. The sheriff isn't commenting on what crime law enforcement was investigating when they went to the home on June 30th to execute that search warrant, and the documents related to it are sealed. It's only been referred to as a parallel investigation.
Yeah.
But there are a lot of questions about how a family of 4 could keep children hidden away from the world and why. The sheriff says there were 16 children in that house. Records from Mason County, West Virginia, show that Gary Jr. and Elizabeth Russell were married on March 31st, 2008. Court documents show the couple had a child a short time later on May 30th, 2008. Now, you might be wondering, why would Elizabeth and Gary Jr. go to West Virginia to get married? Well, in Ohio, you have to be 18 to get married. You can be 17, but you have to have parental consent and then meet a bunch of other strict guidelines, jump through a lot of hoops. Elizabeth Siders was 15 when she married Gary Siders Jr. Court records show that Elizabeth Siders was pregnant nearly every year from 2008 through 2025. She had children in 2008, 2009, 2011, 2012, 2013, 2014, 2016, 2017, 2019, 2020, and then twins, it appears, in 2022, 2024, and 2025. There may have been more.
I'd shoot myself. They don't interact. We have seen the feral kids raised by wild animals, by stray cats. Shut up. No, shut up. No, shut up. I don't believe you.
Children born to the couple in that time that were stillborn. I'm still working to actually confirm that information. Law enforcement said the Siders moved from county to county and even spent time in Wisconsin. And I've learned that Children's Services may have visited the family in one Ohio county, but then the Siders moved, I'm told, to keep the children from being taken away from them. The Siders, according to the sheriff, have lived in the house on Omer Street in Vinton County for the last 4 years. Elizabeth Siders doesn't appear to have social media accounts, but Gary Jr. does. On June 5th, 2014, Gary Siders posted on Facebook, "This is Elizabeth. I don't want anyone putting pictures of me on Facebook, everyone. If you have any pictures of me on here, please take them off of here." Elizabeth's mother wanted to have contact with her daughter. She even wished her a happy birthday in 2020. Elizabeth's mom wrote, "Happy birthday to my daughter, Elizabeth. It's hard to believe my youngest is 28 today. Love you, Mom and Dad." The photo she posted of Elizabeth shows her with much lighter hair, and she looks healthier.
Yeah.
We don't know the date that that photo was taken.
That's weird that she looks like that. Can't class. Stray cats. Bunnies. Cat strut. I'll have to look it up.
Another family member posted these photos of Elizabeth, claiming she took them when Elizabeth was 13. That was the last time that family member said that she actually saw Elizabeth. Now, this raises a lot of questions. How was a 15-year-old girl able to run off with a guy who's 3 years older than she is and get married? And why? Elizabeth's brother, Jeremy, posted on Facebook.
It's because she's always pregnant. My sister.
Facebook on June 30th. My sister just wrapped her life up due to indoctrination. It is 100% real. 20 kids and younger than me. The math equals immature piece of you-know-what man involved. I met this dude a couple of months ago, shook my hand like a baby would, super soft hands, definitely never worked a day in his life. I should have took him out that night. I was thinking about it, but my sister, I was happy to see. Been 15 years. You lost touch with your family, followed another. Look what happened. Now, I reached out to Jeremy Russell, but at the time of this recording, I haven't heard back from him. On Sunday, Jeremy Russell then wrote, got a lot of Facebook investigators, LOL, you're in for a ride. I've been telling you all. My remorse, I don't care. I really don't. That's sad. I tried many times. Ask my ex. She knows. I was the one harassing. I love my sister. However, everyone knew about it. I told everyone. Welfare supporters to the maximum. So state knows something. I don't get it. Just leave me alone. So Elizabeth's brother claims that everyone knew about the children. To what extent they knew about them and the conditions they were living in isn't clear. But he's also implying that the state, or at least Children's Services, which is called Job and Family Services, knew something about the children.
Did you have the opportunity to read that complaint?
All four Siders face second-degree felony child endangering charges, including the grandparents, Gary Siders Sr. and Christina Siders. They've pleaded not guilty to the charges. When the arrests were made last week, law enforcement said the children hadn't been to school and couldn't read or write.
Oh.
The oldest couldn't spell.
Yeah, the state is so bad. Child services is horrible. I mean, I live in Ohio. It's bad.
Their name. But one of Elizabeth Siders' brothers is disputing that his oldest nieces are illiterate, even posting screen grabs from social media accounts.
They probably made them seem like that so they could get disability checks. Not good. Charges, anything with kids, automatic green light. Yep. And they probably made them seem like they were illiterate or dumb or had some kind of autism thing to get more money.
Attributed to them. Joey Russell posted on Facebook, I thought my nieces couldn't read or write. These are messages between her and her ex-boyfriend. He says they had to break up because of her neighbor, Mike. He sent proof of everything. The lies need to stop. The speculation needs to stop. Clearly the neighbors knew. Clearly she could read, write, and speak. We just want the damn truth. Praying day and night for my nieces and nephews. Now, how the teenage girls were able to post on social media isn't clear. Did they have phones, an iPad, a laptop? We don't know. Then another family member posted on Facebook on the 4th of July, well, part of me wonders if she, meaning Elizabeth, wasn't mentally conditioned to think this was okay. The mom in me knows it doesn't matter because there's absolutely no excuse for dragging your kids or any human through your BS to this degree. In my opinion, she's guilty to an extent simply because she is an adult. The justice system will handle the situation however it sees fit. I'm cool with that. But I feel like this also needs to be said. Lots of people failed those babies, and they continue to fail lots of others all over and keep the pattern continuing by not intervening when things aren't quite right. Kind of like see something, say something, or even, see something, do something. People all over the USA right now keep saying, oh my God, how did this even happen? Most people can't fathom, and I really wish I couldn't either. But here's my idea. Generational poverty, deeply embedded trauma, mental illness, and systemic failure by other family and community members all mixed into one big horrible mess. While the parents and grandparents of the children are in jail facing serious felony charges, Gary Siders Jr. also faces 4 misdemeanor counts of public indecency. Court records state that Gary Siders Jr. did recklessly expose his private parts under circumstances in which his conduct was likely to be viewed by an affront of others who are in Gary Siders' physical proximity and who are not members of his household. Now, these alleged incidents happened 4 times between May 23rd and May 31st, according to court documents. Gary Jr. has pleaded not guilty to those charges and the
what a creep
child endangering charges.
How do you plead? Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel. Okay? Mr. Siders, would you like me to enter a not guilty plea for you as well?
Right.
Until you have the chance to speak with an attorney?
Public defender.
I will do that.
So let's turn now to Dorian Baum. He is an attorney representing Gary Siders Sr., that is the grandfather in this family. Dorian, thanks so much for coming on. You haven't met with your client yet. Tell me a little bit about why, and have you even been able?
Public defender. That's why he hasn't met with him yet. Yes, I flash my lights. You kill me.
To speak with Gary Siders Sr. on the phone.
Yeah, thanks. Again, thanks for having me. So unfortunately, because of the holiday weekend, the jail was actually not permitting people to come in and visit with inmates. That includes attorneys. So the first opportunity, and that actually includes today as well. So unfortunately, the first opportunity we'll have to meet with Mr. Siders will be tomorrow. So my intent is to get down there and see him as soon as possible tomorrow.
Your client, along with his family members, is facing, 16 felony counts, second-degree felonies of child endangering. It's been described as a really awful place where these children were being kept, a 12 by 12 room. The sheriff, I believe, said there were feces all around. There were flies on the kids. The sheriff said livestock are kept better than these children.
Oh my God.
What is your response to that?
Well, I would say there's multiple responses. The first one, I do want to clarify for anyone who might be seeing this. They're currently facing a complaint with 16 charges, which is actually an amended complaint from an original complaint that was 17 charges. And that complaint, in the state of Ohio, you have the right to a grand jury proceeding, whereby you have to present facts to a grand jury, and a grand jury will return an indictment if they think there's probable cause. So at this point, they're facing criminal charges in a complaint, but that is not what the state can proceed forward on if they were to go to trial. So first and foremost, the state still already has that extra hurdle to get over. Now, naturally, getting past the grand jury hurdle is not always that difficult, but it's not unusual for a complaint to show a certain number of charges or degree of charges. And then once they get to the grand jury, it becomes something vastly different. So we'll have to see what happens.
Yeah, and then they can offer a plea deal and amend the charges down to, let's see, misdemeanors versus felony. Crazy.
We can get a grand jury. That's the first.
See, grand juries, we do grand juries here, not preliminary hearings.
Thing. The second one is,
and that's a really low bar. It's probable cause.
Absolutely,
is the bar at a grand jury.
It's a low bar, but to say that I haven't seen no bills or that you see charges at the complaint stage as felonious assault, for instance, then by the time you get to a grand jury, maybe it's only aggravated assault, which is 2 full degrees less. So it is. You're right. It is a low bar, but to say it's not a bar at all would not be correct. So that's the first thing. The second thing is, the state has provided what can only be described as a modicum of the evidence. We have gotten so little from the state at this point. As has been reported, we've already filed for discovery. We're asking for the state to provide.
Well, yeah, and they also worked fields and took care of animals, and they just shouldn't run around the house doing nothing.
Added to us. I've had some minimal communications with the state. But from what I've seen, to be perfectly blunt, when I see a press conference where the state AG...
Oh, he's absolutely minimizing all of this. The cat looks good though. It does, right? I want to go get that cat.
He is making these hyperbolic, extravagant statements about what he
Right.
saw, where the sheriff is talking about livestock, is just simply, it's beyond disingenuous, frankly. It appears to me, from what I understand, that these people are really just trying to criminalize poverty and an extremely impoverished family. As many people in the media have already noted and have already discovered, the kids who have been described as feral, been described as illiterate, it's my understanding that as the internet does what it does, it's come out that these older kids had social media pages, Facebook pages, Snapchat pages, which speaks to a couple of things. Number one, if they're so illiterate, how are they posting things online? Number two, if these are kids who are trapped in this place, how are they able to have... Typically, when you see cases where people are trapped or they're not allowed to go do things freely, they're not given internet access, they're not given social media pages. Furthermore, I've seen the inside of this house. I'm pretty sure that the state AG did not see the inside of this house, because when he was making these descriptive statements about what he saw or what he smelled, I'm going to go ahead and guess that he was getting that secondhand from a number of people. And I think for him to come out and again make these hyperbolic statements without himself being really a part of it was just frankly inappropriate.
Well, the AG said he was outside the house. He didn't go in. What have you seen of the inside of the house? Because we're just seeing the photos that were taken, their press photos from the outside of the house. And obviously it does look like it might be a little bit unkept, it looks dirty. But what have you seen that you are disputing the characterization of the 12 by 12 room and the feces and everything where these kids were kept?
So again, unfortunately, because of the very preliminary stage
And
of the game,
I can't speak on it.
everything we've been sent essentially is marked as counsel only, which means I can't actually disclose full details of what I've seen. I can, however, say that I believe the characterization is overblown. I think when you describe that the outside was certainly unkept or was, perhaps looking dirty, I think people can look at the pictures for themselves and see that. But it's not illegal for something to be dirty. It's not illegal for a home to be unkempt. If so, I would suggest there's going to be a lot more people out there with criminal charges they're facing if simply having a few things out of place is really the standard. I mean, that's not the standard for felonious, for secondary felony child endangering. They have quite the burden, I think, to show what they have been describing in their various news conferences and press releases, et cetera. And I think having some pictures of a place being dirty is not going to cut it.
Well, they said they were in a 12 by 12 room, though, with feces and flies all over the place. So, I mean, that's pretty gross. And two of them were taken to a level 1 trauma center. So that's pretty serious. I know the other children were treated and released from area hospitals.
That's right. And so, again, that at this point, we haven't gotten any documentation to show where they've been taken, what the basis for their hospitalization was, if in fact they were hospitalized. I don't know what the status is of these children, because again, the state hasn't shared that information with us. There was clearly a lot of children there, and I'm not going to come out here and suggest that I know exactly what was going on there, because I don't. And that's really the main point, of course, isn't it? That none of us were there. None of us were living there. The state did, I will say this to his credit, Prosecutor Archer, who is the county prosecutor down there, was very specific in saying that this was not an alleged trafficking case. But there's rumors that are flying everywhere about what was going on with these kids, what was happening to these children, whether there was other specific bits of abuse going on. And to date, I've seen no actual hard evidence to show there's any specific abuse.
Well, he's a good lawyer for them to minimize all this. I mean, it does look like they mowed the grass around their house. Wasn't like overgrown and all this stuff. And if you're looking at it from this angle, I mean, they have this pile of garbage over here, but it doesn't look like, I mean, I've seen way worse.
That was being done to these children. Again, whether the question is that these children were in a home that was dirty and that rises to the level of child endangering, whether it rises to a certain felony level, that's something the state's going to have to prove, obviously, beyond a reasonable doubt. But, I wasn't in this home. I personally wasn't in this home, and that's why I'm not going to speak to what it smelled like or looked like specifically. But we don't have all of the evidence. We don't have anything that's showing that these kids were locked in a basement or anything of that nature. This is not what
They were chained to the bathtub, all 16 of them.
people are trying to portray as a case where these kids were, chained in the basement or something like that, something extravagant like you might see in a horror film. It wasn't that. That wasn't the situation, as far as my understanding. So I think, again, we all need to take a step back and let the facts actually bear out.
So your client, Gary Snyder Sr., we saw him when he was in court for his initial appearance, and he was in a wheelchair. Do you know anything about your client, about his physical state, his health, his mental state?
Frankly, I've seen what you've seen, which is I saw it appears that he has limited mobility. My understanding is that he had difficulty hearing. It also seemed that he had difficulty understanding the judge. So I have some of the same concerns that anyone else might have looking at a person whose competence might be in question. As anyone who knows anything about the law knows, the very first step is to ensure that your client is competent. You can't move forward otherwise. So one of the basic tenets of my criminal defense of Mr. Snyder is going to make sure that he's competent to even stand trial, let alone any of the other defenses we might raise. So I guess the short answer is no, I haven't been able to talk to him yet. I don't know anything other than what everyone else has seen, which is what happened at the arraignment, what took place there, et cetera, et cetera.
Tommy Stolley, the attorney for Elizabeth Siders, I saw him in an interview, and he said that her first question was, where are my kids? She wanted to know where her children were. It wasn't how much time am I facing or anything like that. Have you had any discussions with the other attorneys in this case regarding their clients and their reactions to this?
Yeah, I mean, I've had some, again, brief initial discussions with the other attorneys. At this point, it's obviously we are all representing the individual interests of our individual clients, but they are a family. So
Right.
It's my gut.
I'm with you 100%. I would absolutely do that.
Feeling that in many cases their interests will overlap. So I have had some discussions with the other attorneys, specifically again about some of that very preliminary discovery that we've all received and what our general thoughts are. I sort of make it a point not to talk to other attorneys about their client-attorney conversations, as that is, of course, privileged information and confidential.
Right.
But it's not surprising to me that a mother would ask about the condition of her children, bearing in mind that, these are people minding their own business, and a litany of officers come rushing in with guns and arrest them. Don't let them, check on their kids first. I can imagine someone like that being concerned about their children.
Mm-hmm. Gary Siders Jr., your client's son, faces 4 counts of public indecency. He's accused of exposing himself at the house to people who were not his family. We know about that, but law enforcement has been tight-lipped about what initially brought them to that house, the search warrant that was being executed. Those documents are sealed. Do you know anything about this parallel investigation that brought Ohio BCI and the Sheriff's Department to the Siders' home?
Unfortunately, I don't. And as you sort of alluded to, it would seem pretty odd for a couple of misdemeanor counts of indecent exposure to generate the type of response that happened at this house. I would also be very interested to see what this search warrant said, what the basis for the search warrant was.
Yeah, why they were
how they were
go into the house. What gave him permission to go into the house or to even pull the kids out of the house or to see the kids? If the search warrant was there for him, like you said, you can't do it in front of you. But if they were going there because he did this somewhere other than the house, what gave them permission to do the rest of the stuff that they did? I'm with him. I wonder if he's like not a public defender, but if he's a public defender, I imagine with 16 kids, they don't have money for an actual paid lawyer. But oh yeah, that would be an interesting case, because if he's if somebody's paying for him to have a lawyer and he's not, if he's a public defender, he's absolutely doing right by his client so far. Most public defenders just try and make a plea deal and you do some time in jail, plead to this, blah, 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 go about your day. He's actually doing pretty good.
Able to obtain such a search warrant, because I have a hard time believing.
Okay, we're back. I kept watching.
This meeting
More Derek, please.
is to use your statement here instead of your testimony at a preliminary hearing.
The search warrant.
Understand that?
Permission to.
Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements. Okay. First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. Understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that?
Right now.
Okay.
Not
First,
later.
we're going to cover some of the things that we've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twigs.
And do you know Tyler Robinson?
Yes, I do. Well, yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And we described your relationship with Tyler when you first met him anyway.
Feedback.
When I first met him, I didn't know him super well. He was just a new roommate. So I knew he knew my friend group and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone? Okay. I'm going to repeat those admonitions just to make sure we got it recorded. Okay, so again, I placed you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on.
Yeah, you got feedback.
If they're saying that it's echoing. So
Yeah.
I think this one's mic is on.
Okay, sorry.
Okay, you're not on my mic,
but that's fine.
Okay.
Okay, so we should be good. All right.
Thank God. I was like,
Is that mic on?
Yes.
Okay, great. All right. Okay, sorry about that interruption. All right. So you said when you first met, you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates. Is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, What were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher like ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on like where the job was and how long it was for the day. And then on certain days of the week during school, like semesters, he would then later in the day, I think around 5 or 6, go to school. So yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that
I can do that.
Your tissue right in front of your laptop.
Oh, here you go.
Thank you.
Yeah, if he was in court, he wouldn't be chewing that gum.
Thank you.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
Right.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was and told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been, I'd say at most a month before this was when he was asking.
Okay.
A Dremel, right?
Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah. Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And
Can we see it? Everybody's seen it.
I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
All right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
Yeah.
I now want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server, like his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally, who are these people?
This is his friend group. They played D&D together every week.
Oh, he's
Okay.
driving.
And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
Oh,
yes. Yeah, like DM means Dungeon Master. So these are like
thanks, Fred.
most of them are names they're using in the game they're playing currently.
Got it.
It's been raining and hot here, so I get like sinus headaches.
Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
Okay. So we're just going to go through this so that we have a record of the messages.
I don't know why they can't show them. They've been disseminated all over since this all started. I mean, like, people put out, there's so many YouTube videos on this.
Is that an accurate recording of that thread?
To my knowledge, yes.
Yeah.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th. Screen?
Yes.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry. So I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
All this cutting out, you have to wonder what else he said. You know what I mean? Like,
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it. And then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay.
what if he said he was going to go on a mass shooting? I mean, honestly.
Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat,
Okay.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
Played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some like shooting games together, but I didn't know him very well, so that was just when we had like a whole friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay.
Oh,
How about
weird.
political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
What is OKC? I mean, I might know what it is. I just don't know the abbreviation of it. Or it's not clicking in my head.
Okay, so before that you have been.
For a short time, yes.
Okay. And I understand you're going by Luna at some point.
To some people, yeah, but not as an overall thing.
Oh, yeah. Yeah, okay. Sorry, yeah. Maybe we'll do a deep dive into it.
Okay. Okay.
Why did we come back for like blah?
I think that's all the questions I have for this portion. Let me check and see if I've missed anything.
Yeah, no, that's what I'm saying. I can do like that's stuff I like to do.
The Dremel that you talked about, you said he had asked for that, is that right?
Right.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a Dremel then?
Yeah.
Okay.
It was in our our apartment. We had a section where we kept all our like random tools for household stuff in our like lower basement level pantry. So yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was. Yeah.
Okay. I'm going to go ahead and end the recording for the 1102 purposes.
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twigs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twigs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Yeah, sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twigs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twigs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twigs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
She's laying good.
And you kind of made reference to this already, but how did Mr. Twigs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview, he refers to the large crack in the upper left screen. So he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right. April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Oh my gosh.
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twigs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twigs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twigs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twigs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
Lot of
All right, Judge, I would move to admit State's Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court
Already
is
know.
very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of State's Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m. Will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
We could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
We could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight.
Right.
And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
This is while they were spot, but I don't want to chance it while they were parked there. If they had found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4. So just scroll down 1, please, Kimberly. And if you could read starting sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will.
Sorry, now we're on page 6. Continue reading.
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Right.
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please.
What?
And then if we could go to the next page, page 8.
So this dude gets up on a roof.
And if you could start at the top.
1 in 1,000.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
Let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15.
So he is able to do all that, but forgets his gun, where he placed his gun in the rifle, or couldn't remember, or didn't have time after changing his clothes to take the rifle.
And then
that doesn't make any
second
sense at all.
grade message on
Didn't even know
page
what
15,
gun
if
he
you
was
could start
using.
there.
Okay.
Made this brilliant
So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly.
None of that makes
We mentioned a Cellbrite extraction of Mr. Twigs' phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th
refresh your memory.
make more sense? make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. Would have
Okay.
been September 11th, yeah.
Okay, thank you.
Yep.
All right, I'm going to show just for the witness, State's Exhibit 16.2. Let me know when you see that.
Okay, I see it.
Do you recognize this?
I do, yep.
What is it?
This is just more photos of Lance's phone.
And
And these are, these are the
he didn't even know what gun it was. How would he know how to take it apart?
sorry, how to sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
There's a bunch.
And what is it of?
These are the Discord messages of that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twigs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the two FBI agents, and then he again confirms that in his second interview.
Did Mr. Twigs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Aaron. We've already lodged all of our objections on all three phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
This is graphic content. Don't worry. Oh. I was just texting my husband letting him know all this stupid shit. I can't believe they better hope they get a jury that don't look at this shit and go, what? I was changing my clothes and didn't have time to carry my rifle. So I left it in the woods.
I see it.
Do you recognize this?
I do.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this. This is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twigs gets a text from Mr. Robinson around 11 p.m. on September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twigs represented was underneath the keyboard.
Yes, yes.
Did they do a handwriting analysis on it?
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite. And after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, I just want to make sure the record's clear. You mentioned Celebrate a few times. What is Celebrate?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. That's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrate phone extractions. Have you spoken to the law enforcement officers that performed the Celebrate extraction on Mr. Twigs' phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I've spoken to, I have spoken with an SIAC analyst who particularly found this image. I've spoken to her personally as well.
Was Mr. Twigs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twigs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
All right.
I do.
What is it?
These are the images that the FBI released to the public. It would have been on September 11th when those were released. And this was, those are those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does States Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right, noting the standing objection by defense,
Oh my God.
overruling that objection, States Exhibit 16.4 is admitted into evidence and may be published
To the
in
courtroom.
the courtroom.
And again, in the Discord,
This is not normally how trials go. I mean, I know this isn't a trial, this is a preliminary hearing, but normally you can hear everything, see everything, which is what I think all court cases should be. I think you should have media in there so you can see how screwed up our actual system is and how some people get absolutely railroaded in the court system. Some court cases are actually good and fair and just, and other ones are absolutely not. But I think that there should be the public eye so that you can actually see what is going on. This is absolutely oh my God. That's another one. Yeah. I think if you're going to let the media in, you should let the media in, period. The Daybell case was another one that was crazy. But I think if you're going to let the media in, you should let them in, and there shouldn't be any restrictions. Because it leads to propaganda, and it's just disingenuous. Of, well, we can let the media in, but they can't see. We can let the media in, but we got to hide this, and that's basically. Oh, The Reed case. Oh my God. I watched that thing. That's another one. Oh my God. Yeah. That's one that Karen Reed didn't do that, right? That's an absolute total corruption. Let's get real justice beat up, right? Yeah, that whole case, crazy. Yeah. They're still railroading her. There's still a whole bunch of, she's still in court because even though she was found not guilty, they're suing her for wrongful death. And civil is the bar on civil is so lower than criminal, so much lower than criminal. So they're suing her on wrongful death, even though that she was found not guilty, which, yes, everybody goes, how can they sue her? She was found not guilty. And you can, the bar for civil liability is way lower. Shit out of his wife and choked in the driveway. Was wild. Everyone in the neighborhood called police. Someone went out to defuse the situation. The cops came out, and guess what? Nothing happened. They probably sided with him because he's law enforcement. And there is a thing. I live in a city that's disorderly conduct, no DV. Yep. Yeah. I live in a city that is very much brotherhood, gay shit. Yeah. And I have a lot of family members in law enforcement, and they very much stick together. And one bad apple will cause people to look at law enforcement as everyone's bad. And they're not. Not everyone's bad. But I mean, I was married at 16, but I went to bars and stuff like that because, well, being that when you're married at 16, you can go to bars and stuff like that and still have your husband or whatever buy alcohol for you. It's crazy how all the laws and shit like that work. But I had judges because of all I'm connected to. I have judges and police officers buying alcohol from me, getting drunk with them, and we'd all go out, get in our cars, and drive home. Yet that same judge would give DUIs the next morning. It was different then. Yeah. Yeah, it's different than it is now. Yeah, you can't do the same shit that we used to do then. This is ridiculous. So not even Bubba will hear what they're talking about. Did you see the Johnny Depp case? That was a wild case. I watched that whole thing too. World is different. Yep. Yeah. My brother-in-law was the sheriff. Brother-in-law was the sheriff. Nephew's the second in command of the police department. My brother-in-law's brother is the DA. Everybody that I know is all connected. My brother-in-law's dad is chief of police. Yeah, Amber Turd. Yeah. A dog stepped on a bee. That's why I don't believe all women. She was a true abuser. Yeah, when I was doing legal transcription, I watched that case to do legal transcription. I want to talk about crazy. Mm. You think yelling?
As it relates to 5.1, the court previously, the day that I did it, I believe it's day 2, perhaps.
That sounds correct.
The court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. And the court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, and that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense.
We're going to
This
argue
is
it again.
Going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant, how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and it's not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do. And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you.
I can't read it. Clear it up. In the light. Clean it up. Nobody can read it.
All right, I believe that should be sufficient.
Oh, they did dim the lights.
And-
Holy shit, that was bad.
Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twigs. Kimberly, if you could turn to page 17. And because this has already been admitted and, court, correct me if I'm wrong, published not only to the gallery, but to cameras at large, I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request? All right, thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay. This is Tyler. He says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct.
You got his name there.
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail.
Yes,
And that you were the booking officer.
that's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's the individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel? No. All right, I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know, now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, well, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll
So
pick
argue
up with
more.
defense for cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Yeah. Yeah, they picked it up at Dairy Queen.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is
Yeah,
now
he
in
changed his
recess.
clothes. Yeah, he changed his clothes at Dairy Queen. That Dairy Queen's now closed down. You know that, right? They they dismantled it. Yeah, so they dismantled that Dairy Queen's just like gone. They like it was gone like weeks afterwards. Like they didn't have any fryers in it, nothing. It was totally just gone, shut down, everything because people went to it. Yeah. Because people went to it to try to like look in it and stuff like that, but they got the clothes that he threw away there, which was the black shirt and stuff like that. So, but yeah, he turned himself in with the burgundy shirt and the but he was in jean shorts. He wasn't in jeans. So I don't know. So he threw away any clothes. Yeah. Yeah, he threw away clothes. It was in his backpack. He threw away the whole backpack at the Dairy Queen. I mean, he was hungry. I mean, he went to Chick-fil-A. He went to Dairy Queen. He went to Chick-fil-A, or he went to Dairy Queen and got chicken strips and a sundae. He's on camera actually eating. Yeah, he got chicken strip basket and fries and a sundae. After he supposedly shot and killed Charlie Kirk. But yeah, so they supposedly have all that. And then the Dairy Queen was like gone because people went to it. They're like, there's videos of people going to it and it was like just stripped. Like it was never there. But that's what I think it's so weird that he changed his clothes and didn't have time to take his gun. Like what? But that's what I find weird too about so make this make sense to me. So they take pictures of a screwdriver, which now I believe is irrelevant. But they're trying to say because this whole narrative that he took the gun apart, and that's how it was in his backpack. Then it was, then he put it together. It was in his leg. That's why he was limping. All of this shit, blah, blah, blah. And he supposedly climbed over the railing, got up on the roof, did all this shit. And then he jumped off the roof. That's why it was together, in the towel and all this shit. But the screwdriver doesn't make sense if he didn't know what type of gun it even was. And that's what he put in the text message to Twiggy. Then how did he use, why would he need the screwdriver? He wouldn't know how to even take it apart. Right? Some people said that too. Right? Yeah. Oh, a lot of people said a lot of different stuff. They said that he shot him purposely when he said about gun violence and all this stuff. It makes no... Dude, he didn't even know what gun it was, yet he made 1 in a million shot. Didn't even know what gun it was. So and it was his grandpa's gun that he got from some old ass dude. So had he practiced with it? Was he proficient with it to make that type of a shot? Right. Well, that's what I'm saying. Everybody said, because when they brought out the screwdriver, everybody's saying, do all this, right? I mean, you had military guys, Green Berets, all this stuff talking about how they take their gun apart, all this stuff, because they were trying to say, but like this kid, right? Right. I mean, I have a 338. I'm pretty good with it. I have a Creedmoor. I'm pretty good with it. I'm not running, doing all this stuff, jumping up on a roof, laying prone, taking the first shot, hitting it dead. Do you know what I mean? Especially if I haven't practiced. Like I haven't practiced in a while. So if I go out there and practice right now, like, in the winter, we don't go out and practice. So if I go out and practice right now, I'm not hitting dead nuts right now. Like you just don't set up a Lapua and like hit dead nuts. I'm not going to set up my Creedmoor, hit dead nuts. Do you know what I mean? This is going to take me a couple of shots. And I'm not going to go run across campus, jump all over these. I'm not doing parkour, then lay down prone. And in 30 seconds, make the shot. Oh, yeah. Yeah, it's one party for sure. That's what I'm saying. This kid, that's why I have a hard time believing it was this kid. Was he a patsy to go do this? And then the shot was fired and he ran? Probable. But again, now we're looking at, you know, what really happened. I mean, look at Charlie's last message. He was even on Megyn Kelly and said, I'm not going to bend the knee to them. You can't make me say these things. That was within 27 hours of him being shot. That's what I'm saying. I mean, there's a lot of theories out there. Just, I have a hard time believing that this kid did all this stuff, got up there, laid down, and just made this miraculous shot. And I'm damn good with a shot. And I think, I couldn't have done that. I mean, maybe on a good day. But doing all that, I mean, if I was already up there laying down doing all this stuff, but in 30 seconds, are you kidding? I mean, a military person, a sniper, somebody who's done it. Come on now. Right. Yep. Right. I mean, I question. I mean, you have to wonder why, right? I mean, even his own text messages, you know? I mean, as much as I think sometimes Candace is reaching way over the ballpark sometimes, I think, you know, even when she came out with some of her shit and everybody kept calling her a liar, even Erica said, well, I didn't see that message where he said they're trying to kill me. And it was true. She tried to say, no, that's not true. That's not true. That's not true. And then it was true. You know? But who are they? Who are they? Right. We have weather, we have heat, you have wind direction, you have everything that you have to account for. I mean, even when I'm out practicing, you know, you have everything that you have to dial in to get up there and do it in 30 seconds after doing parkour. Come on. This kid did it. He's not a professional. He don't even do it. He didn't even know what gun it was. Right. That's all I'm saying. And that's what I'm like, there's reasonable doubt all through this whole thing. And anybody that's just, I mean, not only that, a 30-06 going through the neck, how was his head still attached? Somebody needs to answer that. He didn't have a neck of steel. I don't believe that line whatsoever. I mean, I was born at night, but it wasn't last night. I have shot many a targets. He drank a lot of milk. Cat milk is super healthy. Goose pate. I'm just saying. You can't tell people to watch something live and then give them facts and go, believe this, and go, no, I shoot guns. That's not possible. I watched it live. And what happened? And the gun that they used, not remotely possible. You should. And not even with the bullets that they found to go with the gun. Right? So you can't use a full metal jacket and then say it didn't go all the way through to the people behind him and to nothing. It went in and down. Wait, what? Because it ricocheted off a vertebrae. No, the ones with where it had the stupid libtard sayings on it. Yeah. The carvings that are supposed to be fascist. Yeah, the engravings. Yeah, I mean, just all of it's so unbelievable. And the fact that Kash Patel came out so fast. We got him. We got him. We got him. You had him so many times. Right. I don't know. Let's finish watching the rest of this real quick. It's almost over.
Arrest warrant, then none of this could have happened. So clearly it wasn't just those charges, because if it were, they would have a simple arrest warrant. They would ask for Mr. Siders Jr. to come out, and that would have been the end of it.
Right.
So obviously there was more there. I'm sure that I and all of my other colleagues who are representing the co-defendants will all be very interested to see what the basis for the search warrant was.
Mm-hmm. So your next step, obviously, is to go to the jail in Southeast Ohio, meet with Gary Siders Sr., and meet your client and talk to him and see what he has to say.
Absolutely. Yeah. I mean, the first step, again, is ensuring that he is competent. That's going to be a concern just based on what I myself have been able to view in the public, and same thing the public has seen. And then make sure I explain to him the process, the procedure. I don't really know what Mr. Siders' criminal history is like, or what involvement he's had with the court system. So after I determine.
No, he's the one that was the flasher. They went in with a search warrant on him, but they didn't have a search warrant for the whole house. So they want to see what the whole thing is. Once they all got arrested, he's representing him. So he wants to make sure he's competent based off of this hearing because he didn't seem like he was okay.
He is competent, if in fact he is, which again, that is a question at this point, but if I'm able to determine that he is competent, and even if he's not, my best attempt is going to be to explain the process, the procedure, what the next steps are. And again, as we sort of talked about earlier, the state's burden to go before a grand jury and bring some sort of evidence to attempt to get an indictment.
Yeah. Well, we'll keep an eye on it. We're as interested as you are. We might be more interested, but
well, because he was the father, yeah, it would make sense. Because the young guy's supposedly the father of all these 16 kids. So if he's out flashing people, that could lead to a probative value. Yeah.
We're interested to learn what the basis for the search warrant was, why they went in there, the actual condition of the children, and much more. Dorian Baum, thank you so much for joining me. I appreciate your time.
Thank you. I appreciate having me on here. I'll be happy to talk with you again.
The 4 Siders family members remain in the regional jail in Southeast Ohio. Each is being held on a $300,000 bond. No word yet on whether more charges could be coming, but the prosecutor left open that possibility. All of the Siders have pleaded not guilty to these child endangering charges. So stay tuned. We'll keep an eye on this case for you. And that's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me. I'll see you back here next time.
The American Pit Bull. You ever notice it's election time? You see more crime. Yep. Yes. That's all this ever turns into be because of that. Do you ever see this guy? This guy's a good guy. Cool thing too. This guy here, Mondo, he does all these parole board hearings. You ever want to see how a parole board hearing goes? This guy does them. Oh yeah. Wonder what she.
A really tragic thing for my family, and I feel like I'm ready.
Is there only 2? Normally there's 4. What state is this?
To come home and do the things I need to do.
Oh.
To try and move on, or
there's the DA.
I guess better myself.
Wonder what
so I can make my family proud and make my sister proud.
Louisiana.
And we are about to watch a soul-crushing parole hearing out of the state of Louisiana. You see, she killed her sister in a DUI crash. And now we're going to see her father plead to the parole board to release his only living child out of prison. This is, again, a soul-crushing parole hearing. The assistant district attorney is here, and I wonder what they're going to say. Anyways, let's jump in, and I'll unpack it at the end.
My name is Caitlin Snyder. My DOC number 7960775.
Okay, and you're here for parole consideration. Let me acknowledge the folks who are watching on or here. We have your grandmother on Zoom, Miss Peggy Gautreaux.
This must be the
from the DA's office, Victim Assistance Coordinator, Tamika White. From the 21st Judicial District, Michelle Sparks.
That's good. You should never.
It's Caitlin Costa from the 21st Judicial District, all on Zoom. And here with us in Baton Rouge is your father, Mr. Pete Snyder. And so Ms. Peggy and your dad want to speak, and we'll ask for their comments at the appropriate time. And is that Ms. Stephanie?
Yes, good morning.
And for the record, could you state your name and your position there?
Yes, ma'am. My name is Stephanie Hodges. I'm in the LPN at Concordia Parish Correctional Facility.
Okay, will you be with us during this hearing? We may have a question or two for you.
Yes, ma'am.
Okay, thank you.
You're welcome.
So, Ms. Snyder,
Probably how well she's doing, if she's taking any classes, if she's got her GED, if she's doing any college, all that stuff that they offer, all the programs they offer while in prison.
Ms. Snyder, I'm just going to read some identifying information into the record, ask you to verify if it's correct, and then I'm going to turn it over to Mr. Tillis because your case has been assigned to him. So you are here today because you were sentenced in Tangipahoa Parish, February 25th, 2025, as a first felony offender to.
I guess I should have seen Louisiana Board of Parole, pardon and parole. Duh.
A 10-year hard labor sentence, 5 years was suspended with a 3-year supervised probation period. So your DOC term is 5 years. You do have a good time date, which is a mandatory release date, and that is November 2nd, 2026. Is that information correct?
The only thing that has changed is my out date. My out date changed to October 14th because I recently just took a forklift class that took off 20 days.
Oh, okay. Well, it wasn't reflected in my record yet. Well, good. Congratulations on that. So I'm gonna go ahead and turn it over.
Well, she gets out pretty soon. It's July. Yeah, that's wild, right? She killed someone. She's 5 years of hard labor.
To Mr. Tillis.
Good morning, Ms. Snyder. How are you?
I'm okay. How are you?
Good. Tell us why you're here and why do you feel that we should grant you a parole today? Tell us what happened.
Okay. Prior to being incarcerated, I was on house arrest for 1.5 years. And during that time period, I did AA 7 nights a week for 1.5 years. I missed a few here and there, but I also did group therapy for 3 days a week, 4.5 hours a day for 8 months.
Holy shit.
I was trying to work on myself and heal from what happened. And I was seeing a psychiatrist, and I was getting ready to start seeing a therapist after I finished group therapy. But then I got sentenced to my time. And I feel like certain parts of healing and grieving, not just for me, but for my family, has been put on pause since I've been in here. Sorry. This has been a really tragic thing for my family. And I feel like I'm ready to come home and do the things I need to do to try and move on. Or
Like, she's been in there for 5 years now, right? Like, she's getting out. Like, they did say 2026, right?
I guess better myself so I can make my family proud and make my sister proud. My dad and I, we wanted to do a nonprofit, and since I've been away, he started it. And it's one of the things that I wanted to do the most for my sister, to honor her.
Yeah.
I just feel like I'm ready to do things that I need to do
What happened?
that I
What
wasn't
caused-
ready to do before.
Okay. What happened? What caused you to be here? Did you have a drinking problem, drug problem, or what?
Drinking problem. Drinking problem.
She better say that she still does. she better say that she will always be an alcoholic. I think that's what they always want to hear. You're a recovering alcoholic, but you will always be an alcoholic.
And you said you were under house arrest before this incident happened?
No, it was after the incident happened. I had to turn myself in, and the bond was too high, but I needed help, mental help. So the judge granted me clinical house arrest. So I was on house arrest after the accident up until turning myself in to prison.
What's the lady's name that's there with you?
Hodges.
Ms. Hodges.
Yes, sir.
Can you tell us anything about Ms. Snyder?
She is a very quiet and compliant.
Right.
Whenever I told the warden that we were gonna be sitting in on this, she didn't even know who she was, and that's a good thing. She keeps to herself. We do not have counseling at our facility. So when she does need to speak, she comes to my office, and I wouldn't speak for someone that I didn't believe, was regretful and needed, the help that she does need. She does need extensive counseling. She does need to get on and get that going, especially with her and her dad and her family. But she is a very sweet person. She's a very sweet person. She does have some medical issues because she was also injured in that wreck, but nothing that's extensive. We've got that taken care of. But she just, my heart breaks for her because I know that, while she's having to do the punishment for what she has done in the situation, she's also having to grieve a loss of her sister. And so it's got to be, I couldn't imagine. I honestly could not imagine.
Okay, thank you so much for your comments. We really
You're
appreciate
welcome.
Can we hear from her grandmother now?
Good morning.
Ms. Peggy?
Yes. Yes. As you've heard, I am the grandmother of both Caitlin and Lauren Snyder, who both resided with me prior to the accident. I wanted to let y'all know that Caitlin and Lauren were extremely close to each other, and they did everything together from daily hygiene routines to socializing. They shared a bond that was very strong and unbreakable. When Caitlin was incarcerated, the judge did state, and I'm reading this because I wrote it all down, the judge did state that she wanted her to get grief and trauma counseling. And as you heard, there was no availability of counselors there. So she's basically on her own there. And there's no visitations there for the family. So we haven't seen her since the day she turned herself in. And we've only been able to communicate with her through the phone and text messages. Her loss is overwhelming, and she has had to carry that weight of the weight of that pain, along with the guilt of that tragedy, on her own. And I sincerely believe that if she is granted early parole, her family will be able to provide her the support, care, and professional help she needs to get to heal and to learn to cope with the loss of her sister Lauren. After all, just like Stephanie said, what greater burden can someone carry than living with the knowledge that she was the driver of the vehicle in which her own little sister lost her life? I respectfully ask that you consider granting her early parole so that we, as her family, can be there to support her and help her to begin the healing process. And if I may, on a personal note, I would appreciate if y'all would consider very strongly letting her come home so that I can have one of my granddaughters for the rest of my remaining life. Thank you.
Thank you so much. And I'm so sorry about your granddaughter. Can we hear from Mr. Snyder? If you don't mind, go to the podium.
Good morning. My name is Pete Snyder. I'm here on behalf of my daughter Lauren, Caitlin.
Oh.
You know, this has been a rough road for all of us. Since September 20th of 2023, when we were all standing behind Lauren, around Lauren, and we had to take off of life support. Life has never been the same. You know, Caitlin and I talk 2 or 3 times a day, you know, and every day that we speak, you know, it's tears in her eyes. I hear in her voice that she's very remorseful for what happened. And like Peggy said, they were 2 peas in a pod. They did together. I mean, everything. And, you know, standing here as a father, you know, losing one child and then loving the other one that's in prison, knowing what took place, you know, it's a spot that nobody would want to be in, but we're here. And with all that said, you know, my daughter needs help. She's getting no help. We've all written letters to the judges, DOC, try to get her moved while she was incarcerated to get therapy. And obviously nothing has happened, you know. And people there in Concordia, they help her, you know, they'll bring her in the nurse's room, let her, you know, cry or talk, you know, but that's about it though. As far as the healing, she hasn't been able to heal. And like Caitlin said, you know, we talked about a nonprofit. I did form a nonprofit in February. It's called Lady Lauren's Life Testimony, and it's Lauren Against Driving Influence. And since then, I started putting a board of directors together. I spoke with some probation officers in Tangipahoa Parish, you know, about starting to speak in front of groups. And I talked with the DA also out there, Mr. Parole, about helping me get this thing moving. But I think with everything that's taking place, that my daughter needs help. She needs therapy. She needs to come home. We want her home. We all love her. I mean, it's nobody that doesn't love Caitlin on our side of the family, you know, and we'd like her to come home. And I think she needs to come home and get help, therapy. And if y'all could help us get her home, I would deeply appreciate it.
Let me ask you this.
Well, it's not that you can't love her. I mean, I understand that you still love her, and it's great that you still love her, but could you imagine if it wasn't your other daughter that she killed? What if it was somebody else that she killed? What if it was a family? And not just your other daughter? I mean, this is why people shouldn't drink and drive, honestly. It's because accidents happen. And it's not an accident. She made a choice to get in that car.
Where do you think her problem started?
I think the problem started back in 2010 or 2012. Me and my wife had some issues, and we were drinking, and then and I think all that just started like a snowball effect.
And then, so they were drinking. They weren't living with their parents, moved in with the grandmother. Right.
And I think that's where it all started, sir. If you know.
You're still drinking, or you?
No, I'm not. I have not. I haven't drank in almost 30 months. I take a Vivitrol shot. I go to counseling once a week for grief therapy and also alcoholism. So I haven't therapy. I take a Vivitrol shot. I haven't drank in almost 30 months. I take a Vivitrol shot. I go to counseling once a week for grief therapy and also alcoholism.
Did he say I take a very small shot? I don't drink, but I take a very small shot.
So I haven't drank in almost 30 months now. Now, I would say that this weekend was probably harder on all of us because every 20th of the month, this 20th of the month made 33 months that Lauren has been gone. And then on Sunday, on Father's Day, Lauren was made 20 years old. So, you know, it's been a rough week on us. And I know Peggy never.
Wait. Lauren would have been 20 years old. So she was only 15 when she died? Yeah.
Everybody else feels it too. And we would all like to see Caitlin get parole and come home and get some help.
The grandmother is your mother or your?
That's my in-law.
In-law.
Yes, sir.
She was saying that you all would have, try to help her. What would try to help her, put her in some programs and stuff? What do you?
Well, when Caitlin did get a DWI back in 2022 and in St. Charles Parish, and we had her get into a diversionary program, and then she went to Woodlake for 28 days. Rehabilitation.
Okay, thank you so much, and I'm sorry about your losses.
Thank you.
Any of my colleagues have any questions they want to ask?
So she got a DUI before the accident. So they tried to get her help. Oh, wow. Oh, but they kept drinking because he just quit drinking. Oh, this is going to be a bad situation for her to go into.
Ms. Ledoux?
Don't have any questions.
Let me ask you something, Caitlin, and I agree with your family. I believe that you do need some intensive treatment.
I bet if they release her, they're going to put her inpatient therapy. Yeah, but then she drank and because she was living with her when the accident happened.
And what did you get out of the Woodlake? That was, I'm sure, an inpatient intensive treatment program. Why do you think that didn't work, for lack of a better word?
It froze again.
I think she froze it again.
I see the nursing.
Okay, it seems to be better now, but it got frozen. Or is it
Yeah,
still frozen?
Go back.
Are we still from? Okay.
Did you hear what the question was?
Yes.
Okay, the question was,
No, ma'am.
I wondered, your father said you did a 28-day program at Woodlake for an earlier DWI, which I'm sure was an intensive inpatient program. And then once you completed that, it appears that you continued the substance abuse, the drinking. Why is that? Why do you think that is?
It was a really hard time in my life.
Seems as though we're having some technical issues.
Sorry about the connection.
Yeah.
But I was just in a really bad spot
Then why
at the time. I was really depressed.
Then why did you take your sister?
It's not a good excuse, but just the truth.
I asked that question because I agree that you need some treatment and you need some intensive treatment, but you got to be ready for it. You're in a more difficult spot now, I would think. So I just want to be sure you're ready to accept and seriously apply whatever treatment may be afforded to you.
I believe that I am. It's like all that I've been wanting this whole time. You know, I've been calling my dad, begging my dad, please get me help. Like just somewhere where I can get help. I need help.
Okay. All right. We're gonna try to help.
I do have,
Go
I
ahead.
do have one question. Caitlin, aside from your father, do you have any other close relationships with people who do not drink?
Yes.
Who would that be?
Well, there's my grandfather, my Papa Jerome. He was gonna speak today, but he decided against it for personal reasons. But he doesn't drink. He had a drinking problem as well. But he has been sober for over a decade now. So I do have people in my life who have succeeded so far in sobriety.
So,
So
not the grandmother.
that concerns me because you need people who don't turn to alcohol as a support or a way to cope.
Well, I do have like friends and people from AA. Like I had a sponsor and I texted with a lot of people and I would go to AA and then people from group therapy. I made a lot of friends and you know, I do have other people, but as of like close relatives, I mean, my dad's had a drinking problem, my mom's had a drinking problem.
My grandma.
So I mean, my grandparents are the only ones that I guess have succeeded in that area.
Okay.
So
Thank you. I just wanted to ask that question. Thank you.
Yes.
Can I say one more thing, if that's okay?
Sure.
We have a close friend of ours in Handwritten, Louisiana, and she was a federal probation officer for 25 years. Her name is Elizabeth Baller. You know, she cares for Caitlin very, very much. She cares for Lauren. Her and I spoke. Caitlin wants to go back. She said she wants to go back to nursing school. Elizabeth said Elizabeth's financially able. She said if Caitlin would come home and want to go to school, that she would pay for college. I just wanted to let y'all know that she does have, you know, others than this big, you know.
Okay,
That's
thank
all.
you, sir.
I apologize.
Thank you. Caitlin,
You notice she didn't mention the grandmother sitting right there wanting her to come home.
Will we be hearing from the opposition? Will we be hearing from victim opposition?
No, there's none.
Okay, thank
I see the remorsefulness in you, but I still feel that you need some more help. And I think we're going to try to do something about that. But my vote today is going to be to grant conditionally.
Okay.
I want to explain that if we denied you today, you would be released on that October date without any DOC treatment. And that is not acceptable for me. And so my vote is also to grant conditional upon some substance abuse treatment prior to release. And then some special conditions after.
Right.
That I'm sure the chairwoman will go over.
And I agree, Caitlin. It's unfortunate you were not able to get treatment during your period of incarceration. Normally, for your offense,
It's July. She's going to be out in October. And that what she said is absolutely correct. If they grant her now, she will have conditional releases plus more, which means it will probably be inpatient, intense treatment, then more shit, probably alcohol testing, all kinds of stuff that she will have to pay for. She will have a set things, curfew, all kinds of things that she will have to do to be early released, or she could just wait till October. I don't understand. Why not just wait till October? And then you're just released and you're off parole and you're off papers and you're free to do whatever you want and be a free citizen again. So why?
I mean, you haven't really served a lot of time. I know to you and your family it is. I would not consider an early release. But because your family supports you, and that's encouraging because they suffer as well. So I will also vote to grant conditionally that you be moved to a facility that will afford you intensive substance abuse treatment. I believe you'll also be given an opportunity for the STAR program, which is similar to what your father mentioned, Vivitrol option and medically assisted treatment. And
this is the crazy thing. So doing that, if she screws up there, she goes right back to prison. I don't know why. You've already done 4.5 years. Yeah, that's true. I mean, I've never done any prison time or anything, so I can't say what I would do. I just think, why? You got a couple months. Right.
upon release, you have to complete that program.
See, you have to come.
Upon release, you will have some special conditions, and that will be, and your parole officer can help you with this, is to enroll in grief and trauma counseling in the community. And I think your family supports that. Some family counseling would be helpful to you too, but I'll leave that to those professionals to determine that. And you will be required to attend at least for the first 9 months, let's say 3 AA meetings a week.
See?
And I hope that you continue that, because as you have said, that helped you a lot before.
So get out in July, August, September, October. So 3 months. When did he put this up? This was up 2 days ago. So she got 3 months, or she's going to do another year. She'll do another year. Or 3 months.
Yeah. We do wish you well. So we're going to get you moved so that you can get treatment, get started on the treatment you need, because your treatment will be lifelong as you.
And this is the problem. If she screws up any of this, you go back to prison. This is parole. These are parole conditions, and you sign saying, I'll finish this, thinking you're going to do this because this is best to get out early. No. It's dumb.
Must know by name.
Mm-hmm.
You must complete it.
I just had one question. Do you know like what facility offers that?
It's a DOC facility. They'll get you moved. It's okay.
Okay.
Oh,
I'm kind of nervous. I have people here like Miss Stephanie that, and I just.
You'll be all right. You'll be all right. You just got to work the program. That's your focus. Good luck.
Thank you.
That was heartbreaking. And after this, we're going to see another hearing that was also heartbreaking. A father who driving to the liquor store drunk, flipped his car and killed his 9-year-old daughter. So we're going to see his family plead for him to get out. He had more than 10 known prior DUIs before that had happened. So,
yeah.
But, you know, when it comes to this hearing, it's interesting. If it wasn't Like if it was a different situation, if it wasn't her sister, if it was a hearing where we just heard her talking, I would have had a very different approach. And I think the parole board would as well. And I think this is quite understandable because there were still certain things she said, like, I just want to move on with my life and different things. It's just the attitude, the overall, like, where it just, had it not been her sister, there would just be a whole different sentiment. Obviously, because of the circumstances, because it's her sister, I'm just gonna, it stops right there. I'm not gonna. It's it's unfathomable, right? It's unthinkable. You can't even. And it's about the family. It's about the parents. It's about they lost 2 daughters and 1 shot right there, and it's just a horror. It's just a horror. You can't wish this upon your worst enemies. And then if you want,
You don't. But she also made the choice. I will say something. If I flip my truck and my child died, what am I doing? Better to die by your own hands than any. What am I doing? Better to die by your own hands than anything. It's dishonorable to do otherwise. Right. I'm gonna play this. I'll be right back.
I don't say anything. It's like it's kind of how the prison system failed everyone as well. I mean, you're in prison for vehicular homicide DUI, and she was about to get out, and she couldn't take programs. Like, how does that happen? How does that? How is the system do that? Fail so horribly, and you don't really see that often with DUIs. Usually 2 things happen. They either go to work release, and we see that actually happen quite often. They go to work release to get no treatment, or they go to treatment, but they get like just so bizarre. And by the way, her first DUI, it wasn't just a DUI. Sir Richard found this. Her first DUI was driving 30 miles over the speed limit and reckless operation without a motor, an accident 0.8 to 0.15. And like that wasn't enough of a wake-up call. What can you say? I really don't. It's a soul-crushing hearing. I don't really have anything else to add. We're going to jump into another one. I have an update for you at the end, and we did play it many, many years ago. Very few of you saw it, but I will read your comments and give you an update on where he is today. So with that, let's jump in.
All right, please introduce yourself, state your name and DOC number for the record.
My name is James Thomas, 169-400.
All right, James, my name is Brendan Kelsey. Along with me is Miss Jackson and Miss Wise will be your panel. Explain the process to you, read some information to the record, have a parole interview, ask you some questions. You can respond. At the end, you can make a statement. We'll take a vote. You understand the process?
Okay. 30 over is a felony here. Most states 25, I would think. 95 miles per hour. They're facing good luck stopping. Or most hurt deer, right? Oh yeah, it's aggravated vehicular homicide if you're going 45 over, I think.
Yes, sir.
And then we'll have Miss Lucille Landry speaking at the appropriate time. We'll have Mr. Jacob Thomas speaking and Miss Chelsea Landry. We're also in opposition. We'll have Miss Margaret Hasty. James Thomas, DOC number 1694004, class offender.
Oh my.
Parole eligibility date 11/14/2012.
Wow.
Good time date 2/19/2038. Full term date 2/14/2039, 35 years. Operate vehicle, driving while intoxicated, 3rd offense, operating vehicle intoxicated, 4th offense, and vehicular homicide. Does that sound correct?
Yes, sir.
How old are you, Mr. Thomas?
62 years old.
How long have you been? How many years have you been incarcerated?
18 years, 9 months.
When's your last disciplinary write-up?
2020.
What was that for?
It was fighting.
What about it? Anything before that? What you have? Do you have any intoxication while you were in there?
No, sir.
What do you currently do there?
Right.
In jail.
I'm a librarian. I deliver books to the Beavers. My job.
Okay. And have you been to Steve Hall?
Yes, sir.
And when did you go to Steve Hall?
I went to Steve Hall in 2018 and I got out in 2019, 9-month program.
Wow.
And that was let's see, you were heard, and just so you were denied after you had gotten out of Steve Hall?
Yes, sir.
Yeah.
What'd you learn in Steve Hall about yourself and about your addiction?
I learned where my problem started. They got a program over there they call motor recognition therapy, and it takes you back. It's sort of like the 4-step or the 12 steps, AA, and it takes you back in your life, your past, your history, and finds out where your whole problem started. And mine started when I was 17 years old.
Doing what?
Sir?
How'd it start at 17?
I lost my brother in a car accident, and I guess to cover up all the hurt and pain I was going through, I started drinking, and then it just spiraled out of control. And from that point forward, I became an alcoholic.
Wait, he hurt his brother in a car accident?
And then after that, I couldn't stop.
And did you ever try to get treatment while you're out there? While you were out?
I did, yes, sir. I went to AA meetings a few times, but I don't know. My alcohol the alcohol in was just so bad that I couldn't stop. I'll be honest.
So tell me about the night of the accident.
Sir?
Tell me about the night of the accident. Where were you going? Where were you coming from? What were you doing? I know you had your children.
I was coming from Gulfport, Mississippi, and I was going to Grand Island to bring 2 of my youngest children to be with their cousins and nephews for Valentine's Day. Anyway, when I got down around Bouchon area, I come around the curve doing speed.
Let me ask you a question before that. So you had been drinking obviously before that?
Sir. Yes, sir. I
You had been drinking just on your own, by yourself, at a bar? What?
I drink by myself. I don't go to bar rooms and all that.
So you have been drinking all day? I mean,
yes, sir. I started drinking that morning, and that afternoon when we got in the wreck, I was intoxicated, ran off the road, hit a light pole, killed my daughter. And this is where it ended up.
How old was your daughter at the time?
9 years old.
And you had several DWIs before that, though, correct?
Yes, sir.
Any time in jail?
No, sir.
They just kind of let you go?
Yes, sir.
What so you had some hospital stays. You have any medical condition?
Here.
Yeah.
I cut my fingers off, and I ended up in the hospital
He cut his fingers off? Jesus.
for that. And other than that,
how'd you cut them off?
With tapes off.
Okay, so you got them back on. I mean, you can use them. Oh, tops up. Tips. I got you.
It just chopped the first digits off.
I,
But anyway, I went through some medical treatment or some tests for my heart. They did some tests to see if my heart, they thought something was wrong with my heart. It ain't nothing wrong with my heart. Then they did some thing where they stuck some scopes up in my arms to go check my arteries because they thought it was collapsed. There ain't nothing wrong with them. So other than that, I have no medical problems.
and what
I'm not judging him. I'm shocked that he cut his fingers off. I mean, this dude's had a fucking life, man.
So what's your plans if you were to be relieved, let go early? Where would you go? What would you do? What's your plan?
My plans is to parole to my son's house. After that, the first thing I'm gonna do, I'm gonna report to the parole office within 24 hours. After that, I'm gonna become active in an AA group they call Between the Bridges in Gulfport, Mississippi. I'm gonna get a sponsor.
I didn't think that he did it on purpose. It's not like he's like, well, fuck it, just cut my fingers off. I'm just thinking this poor dude has had a hell of a life. Like, you know, That's why I always say people shouldn't, like, think that you have a bad life, because there's always somebody out there that has a life way worse than you. Like, people that are like, man, my life sucks. There's always somebody out there that has a life way worse than you. I mean, look at this dude.
And then I got a job already. So I'm gonna go to work and I'm gonna
Okay,
stay.
what job?
I have a job where it's cover up, painting and drywall in Gulfport.
So you're gonna move to Gulfport? That's where your son is?
I mean, I wasn't sitting there like being like, I was just shocked that his cut his fingers off. Not like he cut them off, like, never mind. Shut up.
Yes, sir. Well, it's in in Salsa.
Yeah, over in that, yeah, associate over in that area, right?
Yeah. Yes, sir.
So what do you think about your addiction? Is it something that you gonna have to?
I mean, my dad was electrocuted twice, or he was struck by lightning twice and electrocuted. Not on the same day, but I'm always amazed by people's stories.
Fight the rest of your life? NA the rest of your life, or you think you got a kick?
I got control of it. I really do. I study AA. I might shouldn't say this, but I'm gonna say this. Mr. Wide was on his board last time I came up here. And I sort of take him as a sponsor to me, because he told me that I need to wake up to AA for the rest of my life. I took that advice seriously. And I don't only wake up to it, sir, I go to sleep to it. I became an AA member here in Hunt. I am a member of the AA group, and I've been through every substance abuse treatment they got this in the last year. So I got control of it. I know how to handle it now.
So how are you gonna handle that? Are you gonna stay involved in AA every day, or what are you gonna do?
Yes, sir. I will wake up to it, and I'm planning on going to 3 AA meetings a week. And I want to give back to my community by helping other alcoholics. With the experience I have, I should be able to help.
But what?
Or do you have any input for me?
I just want to add that he is a trustee in his current job as a librarian. And, he has taken advantage of a lot of treatment, from Steve Hall, living balance, anger management. He's done a lot. He's definitely on the right track. I think he understands the seriousness of his addiction.
Okay. All right, thank you. All right, we'll hear from now Ms. Lucia Landry. Would you like to make a brief statement?
These women are tough. These two women that are sitting next to him, they're tough on parole boards.
Okay, she can. Yes, I would like to.
Okay, go ahead.
I have been James's partner for over 31 years. I'm here today to support him and hope that after 18 years in prison, James will be granted parole. Despite his history of significant transgressions, I believe James has realized the error of his ways and is ready to embrace his sobriety and become a productive member of society. He will have the full support of his family to ensure he remains in recovery. We as a family will continue James's healthy habits of attending AA meetings by ensuring he will have transportation to those meetings. We are going to have a zero tolerance attitude when it comes to the temptation of relapse. We know for James to continue to, we must keep any and all temptation from around him. James's family will not tolerate any drinking. He's made use of his time incarcerated by learning new trades and improving on that which he already knows. He has aspirations of supporting a father-son mechanic woodworking business if released. As you should know, he has a job waiting upon his release. James is very much loved and missed. Our family has grown significantly in the last 18 years, and we very much love to have him home where he belongs. We are a very tight-knit family that keeps to themselves. That's why it's extremely important to us to have James home with us and return to his role as head of our family as a husband, father, and now a grandfather. James has 14 grandchildren here in Mississippi that are anxiously waiting to meet their grandfather. I will conclude my letter by saying losing our baby girl Jade was a tragedy which I would not wish on any parent. Losing her is still very hard to deal with, and although we have grieved, we have yet to grieve as a family and hope. On behalf of our entire family, I'm pleading with the great state of Louisiana to really have mercy on us and release James. Thank you.
All right, thank you. All right, now we'll hear from Jacob Thomas.
Well, I didn't write nothing down, but hold on.
Let me gather myself. It's been 17 hard years growing up without a father, but I will make sure he does everything he's supposed to do, and he will not be he will not be around any temptations such as drugs or alcohol. He will be going to any AA meeting he asks me to bring him to, and I will make sure that he is constantly busy doing something as far as work or helping me with around the house activities, such as remodeling and stuff like that. So, with that being said, the environment he's coming to is a very loving and caring environment. It's not no negativity over here. I don't do that. So,
all right. Thank you so much. Thank you for your comment. We'll hear from
Okay.
Chelsea now.
We're all gonna go up.
One second. These last 18 years have been a long, hard road for my family and I. I not only lost my sister, but in a way I lost my dad too. Many special moments and celebrations we have not been able to share with my dad, but many more in the future I am hoping he will be here for. I believe losing a child would be a real eye-opener for anyone. Understanding the mistakes and learning from them, seeing my dad work hard to become a better person has been a great thing, not only for him, but for our family. We have been grieving for so long with one another, but my dad has had to do this alone. The pain we all feel will never fully go away, but with my dad home, we can finally heal as much as we can. Coming home will be an adjustment, but he will have us to his full support system. We are here to make sure he makes every meeting and anything else he may need to get to. He has a lot of time to catch up on with all of his grandkids. We would be very grateful if he can start making special memories with them. I'm asking that you allow us the start of our healing and let our children grow up with their grandpa.
All right, thank you. Now we hear from Ms. Margaret Hay.
Yes, good morning again. Just wanted to bring to the board's attention, Mr. Thomas, as you are aware, is also serving a sentence for a fourth offense DWI out of Jefferson Parish, which he was sentenced to 20 years on February of 2005. While he is almost completed the full term of that sentence, he, of course, is also serving this 35-year sentence. And the state would like to suggest that if it is the board's decision to parole Mr. Thomas, that he be mandated to wear a scram bracelet for public safety reasons. That would be it. Thank you.
Oh,
thank you. All right, would you like to make a statement on your behalf?
Ain't that crazy? So the one girl got 5, or she got 10, but 10, 5 of it deferred, and she served 5. He got 35.
I have a question. I'm sorry. Warren, for some reason, we did not get his disciplinary report. How many has he had in his 18 years of sentence total? How many, right?
38.
38. And none of them were intoxication or anything of that nature? Just give it through.
No, ma'am, not that I saw. I looked through them yesterday. I didn't see any.
All right, thank you, sir.
All right, would you like to make a statement on your behalf, Mr. Thomas?
No, sir, I think everything's been said.
All right, great. Stand for the vote. I'll vote first. Got a lot of support, man. Look, you've been through put your family through a lot. Put your family through a lot. That's all I need. A lot of drinking. I mean, year after year after year. You caused a lot of problems throughout your life. I know it's something that you'll have to deal with. You'll have to continue to work on. But you do have really good family support, and that's positive. That's a good thing. I am concerned. I'll be honest with you. I'm concerned. Anytime someone like you comes in front of us, it's difficult because public safety is our number one goal here, and it is concerning. But look, I see you've done a lot of time. You've got all the good family support. You got some good award and comments, and you've taken a lot of good classes, and you've done well. So my vote today would just one vote would be to grant to Gulfport, Mississippi. Go to Gulfport. I want you to go to NAA 4 times a week. I want you to maintain full-time employment. I want you to have community service, 6 hours a month. Speak to people that try to help somebody. Go to church or wherever. And then, and also I would add to wear a scram bracelet at least for the first 6 months, to see if we, to make sure things are going well. That would be my vote, and just one vote. Ms. Wise?
Mr. Thomas, I want, I'm concerned about you.
I can't hear her.
I said, I am concerned about you. I wasn't saying anything. I was paused. I wasn't saying anything. But I feel inclined to take a chance on you. And I am going to take a chance on you. My vote is a grant conditionally upon ICOPS to Mississippi is approved and the square bracelet. And I would like for your family to get involved in Al-Anon. That would really help them transition. It's just a suggestion. We can order them to do anything. But you can suggest it. They can walk side by side with you, with them having a little more learning. And what really stood out to me is your family said they're going to change their life for you. They're not going to have any alcohol at Christmas, no wine. You know, they're doing their part. Right. So you got to go forward. Best wishes to you, sir.
Thank you, ma'am.
All right, Mr. Thomas, likewise, I'm going to vote to grant.
Now it's
The fact that you haven't had it.
usually
Right up.
40 rules anyway.
And if being responsible for the death of the child isn't enough to get you away from alcohol, then nothing ever will. And I think that you understand the magnitude of what you've done. And so my vote today would be to grant, have a strong support system with the financial grant to an ICOS to Mississippi.
All right, you have 3 votes to grant your parole. You understand stipulations. You'll go to Gulfport, Mississippi. You have NAA 4 times a week. Maintain full-time employment. You have community service 6 hours a month and 6 months scram breaks. Do you understand stipulation?
Yes, sir.
All right, 3 votes to grant. Your parole's been granted. Good luck to you.
Thank you very much.
They granted, and I'm not sure if he ever made it to Mississippi because he passed away September 5th, 2025 in Louisiana.
Oh my God.
Now, that's all I have is the obituary.
Oh my
But
God.
I guess one might assume he, for whatever reason, in the ICOTS didn't make it to Mississippi, or maybe he came back. I don't know. But one might call it I don't know how you call it, but I guess he never relapsed. And I suppose that is the conclusion to the story, the most that you can do in this situation. It was also a heartbreaking hearing. And I'll go over the facts of the case of that day. It was horrific. But just seeing their family there, and it was something interesting. I don't know. I can't quite put my finger on it. You know, it's a little weird to say this, but it almost reminded me of that show Shameless. I don't know if you've seen it, but it was like the family sitting around the TV and not the TV, the screen, and they're all sitting there, and the dad who's been a deadbeat dad, and he's sitting in prison, finishing a 20-year sentence, and they're all, you know, just supporting him around him. I don't know if you guys ever seen that show. And they seemed, you know, just so supportive and genuinely happy and outpour of emotion. And they're a unit, which, hey guys, I mean, I know there's like one way to look at it is it's off-putting seeing everyone kind of in their pajamas at a parole hearing. And that's kind of where the Shameless thing came to mind. But there is something unique that even a lot of families in much better situations can't say, and that's be a family unit. And I'd like to think that he never picked up a bottle again and that he passed away of old age, surrounded by his loved ones. And look, it's hard to, again, wrap one's mind around this stuff. And seeing a Miss Jackson hearing without having it Miss Bonnie Jackson Classic is disappointing too. Let's be real. We're all hoping to get something, you know, a little bit of words of wisdom at the end. But any hearing led by Brendan Kelsey, oof. Guys, I'm sorry about this. I know it's like, you know, if you're in who wants to watch this, but it's important to share. It's important to see. It's important to reminder. Anybody struggling with booze, don't get in that car, man. This is the horrificness of the article. Dad whose DWI killed daughter gets 20 years. Written in 2005. A man who caused the drunk driving wreck that killed his daughter and injured his son will serve the next 20 years behind bars for the crime. And that was the son who we spoke to, who we heard from. You know, the poor boy, 8 years old, had to witness it. All of this happened. You'll see soon in the article. On that note, thank you, Annan, for recommending the prior hearing and service for pulling up that research. James Thomas, 54, a former Grand Isle resident who had been living in Mississippi, was convicted of vehicular homicide in December. He learned his fate Thursday during a sentencing hearing held in Judge Bruce Simpson's courtroom. Thomas also learned that there's a chance he'll spend the rest of his life in prison if he's convicted under the habitual offender bill that the parish district's attorney, Cam Morgan, filed against him. Thomas has been arrested for DWI at least 10 times, but authorities think the total is much higher. And this goes without saying, the blood is on the hands of the judges and DAs in Louisiana that allowed this to even happen. And we see this in Connecticut too. I just covered a parole hearing for someone who's had 6 DUIs in Connecticut, and their legislation only allows it to say third DUI plus. Like, they don't even keep track after that. And so that means they don't even have legislation to send someone to prison for longer after that. It's all a very broken system. But, you know, what do we know? We don't have PhDs. Morgan said, I do not think that Mr. Thomas is remorseful for understands his crime. To us, Mr. Thomas deserves the maximum sentence he can get. Thomas' daughter, 9 years old Jade, was killed in the February 14, 2004 crash that happened when Thomas's truck swerved off the road and landed upside down as he was driving to Grand Isle in the Fourth Parish. Expert witnesses who testified at Thomas's trial said Jade Thomas's neck was broken on impact. Thomas's 8-year-old son, Jacob, who told the jury that his father had made a special trip for the bottle of vodka that night, was also a passenger. So I agree with the comment that we see this in DUI people all the time. He went to trial. So he kills his daughter. I know he's dead now and the whole thing, and it's a struggle with it, but it's something that we're used to seeing with these type of DUI cases. They're not just DUIs, there's something more to it, that he then put his son on the stand, like, to save himself from going to prison for how much was he hoping to save? Like, what was his hopes for? You know what I mean? He was willing to put his son on the stand. On a special trip, her bottle of vodka that night was also a passenger. Thomas's blood alcohol level at the time of the wreck was 0.24, 3 times the legal limit. The wreck was the accumulation of a long history of runs with the law for Thomas, many of which were alcohol related, and outcry over how multiple DUIs had slipped through the legal system resulted in a state law that establishes a database of various jurisdictions can track such cases. See, there's always an outcry. Let's make a database. They have databases to track everything, but you know what I mean? But no. It takes this to let's make a database. It always takes a tragic tragedy for then someone to show up and say, all right, blah, 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 blah. It's like, shut up.
Dude, he got paroled and he died. Welcome back. You'll have to watch the end of it. He got paroled and he never made it out of Mississippi. Or he never made it back to Mississippi. He got paroled and he died. But then his whole story, he put his own son on the stand to try to save himself. And his blood alcohol was 0.24 when he killed his daughter. Oh, it's horrific.
Thomas entered a not guilty plea to habitual offender charges. The bill is filed against someone who has a prior felonies because it increases the sentence. Basically,
this was his 10th, or he had 10 prior DUIs before he killed his daughter also.
The more felony convictions a person has, the more jail time he faces. Simpson explained why he imposed a 20-year sentence, the maximum penalty that the judge could have received under the law. It's a tragedy that a young girl died as a result of your actions. It's a tragedy because that girl relied upon you for safety. You have taken away from that child the chance to experience the things that you have experienced. As Thomas stood before the court, Simpson read a long list of crimes Thomas had committed, 7 DWI convictions in Texas, Georgia, and Louisiana, including a 2002 felony conviction in Ascension Parish, 3 felonies in Texas, and 1 in Louisiana, including theft and felony criminal damage to property. I mean, yeah, again, it's your criminal history proves beyond a doubt that you are a serious threat to anyone who operates a motor vehicle, and you represent a serious threat to the public. Thomas declined to speak on his own behalf prior to the sentencing, and he reacted angrily after hearing the judge's decision. How do you not make a statement? He blamed the crash that took his daughter's life on a lack of signs notifying motorists that the construction was being done in Louisiana 1. The only reason I came to this trial was to prove that. It was the highway department's fault not putting up traffic control devices, he said. It's all cool. That's all I got to say. Oh my God. I'm sorry guys for bringing this up. This is terrifying. He's saying this dude, he's a bad dude. But I don't know. Maybe this can be a story of redemption. Maybe this can be a story of forgiveness. Maybe this can be a story of change. He didn't pick up the bottle. He didn't get revoked. He didn't. I don't know. I'm not a fuzzy wuzzy guy, but he is dead, and We just saw the family crying for him. Thomas must stand trial in charge of 14 WR pretrial proceedings. And yeah, there's also an appeal. He appealed the sentence, and in the appeal, they go over the facts of the case, how the police, it's just, you know, maybe we should just go for it. I don't know, it's rubbing salt, but it was a horrific, this is how it happened. On February 14th, approximately 8:30 p.m., officers Brooke and
Oh, I'm over. I don't care. Oh my God, that's stupid. All right. Anyway, okay, so they're gonna wait till. All right. I've been live for 5 hours. I'm going to end this stream. Because it's 5 hours. YouTube gets mad, doesn't let me do any like stuff. End this stream and then see when they come back. Oh, they are back. When did they come back? Did they just now? Oh, they came back a little bit ago. Crap. Okay. Thanks for the stream. Yeah, you have a good day too. Okay, I will be back. I think they're coming back tomorrow, right? Yeah, it is Friday. All right, I'll be back tomorrow, 10:45, do another stream, pick up. We'll talk about what they do this afternoon because I don't want to do another like 5 hours. Too much to happen except them doing, yeah, trial matters, right? All right, I will be back tomorrow though, at 10:45, and then we'll do some more stuff, play around. But thanks for joining me, and you have a great day. Till next time.
Man, club just a system, but the deck set to fail. You speak for transparency, they call it a crime. Next day, you suspended for 6 months of your time. Pedigree, politics, trophies on the wall. Vanity awards while the ethics take a fall. They say it's for the free, but we know what it is. Power in the clubhouse, silence in the pit. Pedigree, politics, ribbons and lies. Smiles at the banquet, but the truth in disguise. You can muzzle the voice, but the truth don't quit. Dog show, kingdom built on counterfeit grit.